I am the my lord plaintiff opposite party.
Yes, my lord, assigned to your lordship, my lord. If this can be taken up tomorrow, my lord.
Yes, yes, sir, tomorrow.
Mr. Mukherjee is leading Kumar Mukherjee. He is not in court today.
Well, I am the plaintiff opposite party, my lord. Matter will be taken up tomorrow, my lord.
Acceptance of additional written statement.
Not accepted. Leave was not granted.
लिखे नहीं
जरा कागज देना।
Order 39 Rule 4. Under 2 prayer, my lord, liberty to approach the appropriate forum in accordance with law and replace the original certified copy with a photostat.
that is usual लिखे नहीं
না না
Sir, mentioning হয়ে গেছে এখন নয়।
yes next
Well, I beg to appear for the petitioners, my lord. My lord, this civil revisional application is for expeditious disposal of original suit number 25 of 2017, my lord. My lord, kindly comes to page 12, my lord.
what is this suit for
My lord, suit for granting letters of administration filed by us, me, my lord. My lord,
What is the state?
My lord.
State.
stage, my lord, order 1, rule 10 to application is pending.
Trial has not begun as yet.
No, my lord.
2017. suit.
Yes, my
I am appearing for the petitioner, my lord. I have served the writ petition of all respondents. They have duly received, and I am submitting the affidavit of service.
You are appearing for?
I am applying for the WBACTC, Lordship.
There are private respondents also.
Yes, yes. They have also received.
What is your prayer?
My prayer to disconnect the electricity connection. The private respondent are enjoying the electricity connection by hooking. On earlier occasion, I made a application before the electricity
but
authority disconnected the same.
Lordship, in this matter, what has happened is earlier, my lord, another
Is there any
application.
hooking? Have you checked up?
Lordship, may I just submit? Lordship, earlier there was a writ application filed before this honorable court. That writ application is still pending, Lordship. Now, in their present application, Lordship, they have said that since they had filed that earlier application, that hooking was stopped. That hooking line was disconnected and a case was registered against the private respondents. Now, presently, they have come up with the same allegation that they have again started hooking. And Lordship, for that reason, Lordship, I'm just praying before my Lord to kindly grant me around 1 week's accommodation, Lordship, because an inspection is to be conducted as to whether they're actually doing that hooking or not. If they are, then we shall take actions against them, Lordship, and we shall file a report before my Lord on the next date.
Very well.
A week's accommodation, Lordship.
And how are you aggrieved by this?
They are the neighbors, I think.
No, my lord. Unauthorized occupants. Landowner is the petitioner.
From your line, it is being done.
My lord?
From your connection, it is being done.
No. My lord, unauthorized hooking is being done by the private resident. There is a pole outside the
The petitioner
land.
complains of
I am for petition, I have served, my lord, but the agreement not show the only private respondent. Other respondent, my lord, received, my
What is your problem here?
lord. My lord, no, আসেনি, deliver show করছে।
Oh, private not served, not served.
Not sent. My lord, fact is that, my lord, petition is absolute honor of the Bastu land, my lord. For he he went to my lord, Bangalore for treatment, his son, mental handicapped son, my lord. He stayed there 3 years. In the meantime, responding authority forcefully and illegally installed the transformer and high tension line. Petitioner made several representation to the
Respondent have done what they have?
my lord.
What they have forcefully done?
My lord, I went to Bangalore for treatment my son. Stayed there 3 years. In the meantime, without permission, forcefully, illegally, the respondent authority installed the transformer and high tension over my Bastu land. I made several representation. Largely, my respondent number 5 served a letter, my annexer P8, direct me to page 22. Direct me to cost for human scheme cost, my lord. Thereafter, made page 22, my lord.
Yes.
Thereafter, made representation, my lord.
You are agreeable to bear the cost.
No, this is my land. They forcefully,
Yes, sir. Why did you
My lord.
install the transformer there at their land?
yes.
No, my lord, the transformer was installed long back in the year 2015-16. But there, at that time, my lord, there was no objection. My lord, from that transformer, my lord, the electricity.
When did you purchase this land?
Long back, my lord.
When?
I have annexed the LR record, my lord. Annexer P1, my lord. That time I went to Bangalore, stayed 3 years for treatment of my handicapped son, my lord. Annexer
Page?
P1, page 11, my lord.
This LR record will not show when you purchased.
No, it is
At what time did you purchase? After the installation
My
or
lord,
prior to the installation?
he got this land by his father. Original land.
When did his father purchase? That also him.
No,
his father
father
may have
versus
purchased-
grandfather CSRS record was.
No, my lord, it belonged to somebody else. My lord, he claims that he has purchased.
My lord, I have no
if it is
instruction.
If it is found that the transformer was installed
My lord.
after you have purchased,
No, before.
then,
My
then you
lord.
may have a case.
My lord.
If it is found that the transformer was installed prior to your purchase and you
No.
purchased with the transformer installed over there, then you may
No,
not
no.
have a case. That is why the court is putting this
No.
question.
ওর কি বাবা কিনে অনেক কিছু Well, some residence is there. Is Bastu land,
This
my lord.
transformer is not for high tension purposes.
No,
Well, that-
yes, my
I'll
lord,
see the
high tension
judgment.
line has been drawn. My lord, 25, my lord, one ice mill is there, my lord, which has been, my lord, given the connection from
It is
that
a
transformer. and
transmission line.
25 to 30.
Is it a transmission line or a domestic line?
No, my lord, domestic line has also been given. My lord,
Commercial.
In his land, the
25 kVA transformer.
transformer will not be there for a transmission line.
No, no, 25 kVA transformer is.
That cannot be a transmission line.
But
It has
my lord-
to be. It has to be another line. It can't be
your lordship,
transmission
your lordship,
line.
yes, your lordship knows, my lord.
Transmission line will not be required. Transformer will not be required there.
No, over my land, my lord, transformer, my lord, 1100 volt, my lord, transformer, high tension line, my lord. I have a judgment of
tension
division,
line,
my lord, kindly see, my lord, over my land, my lord.
Boundary of his land.
Lastly, they asked me to deposit the scheme to remove. What? Kindly see the judgment, my lord, division, madam. के दिन. Division में जान जाओ और high
Transformer.
THL 2004 বলছি দাদা বলে দিচ্ছি এটা বলে দিই CHN 2004 ভলিউম 3 565 পেজ জাস্টিস মাথুর আর অসীম 565 না 565 পেজ ঠিক আছে জাস্টিস মাথুর অসীম মানে কাগজ অনুমতি ছাড়া দিতে পারবে আমি তো ল্যান্ড আপনি সেটা বলে আরে আমি
There are subsequent judgments also.
মাই লর্ড
There are subsequent judgments also. In case of transmission lines, law has changed.
ইনস্টল
Law has changed a lot. There are Supreme Court judgments
no.
thereafter. What? No. First read the law, then say no.
my lord They forcefully,
Supreme
illegal, with
judgments-
my consent, my lord, they install them.
There are Supreme Court judgments to that effect. You are entitled to compensation because transmission lines are for general public purpose. It is not like a domestic.
Without my
distribution
consent,
line.
my lord, without land acquire, my lord.
Kindly see, my
Land
instruction is,
acquisition is not required. Only compensation for the purpose of installation. Entire land is not going to be used up for the purpose.
as per my instruction, transformer has been installed in 2015. But his first representation as per his averment, my lord, is in the year 2023. All these years
Yes,
he was
time, my lord, I stay in Bangalore, my lord.
3 years.
for 3 years.
3 years, my lord, stay.
So 2018, what made you make the representation in 2023 after 6 years?
No, my lord,
What no, my lord?
23 first
Yes.
representation.
So if you were in Bangalore at that point of time, if I take it
Yes.
in 2015, then till 2018 you were not there.
Thereafter,
5 years thereafter, what were you
thereafter,
doing?
my lord, several them went to the electricity office, my lord,
Where it is
requested
said that
date, my
you
lord.
went there and in 2018 you have gone there
Now,
for 5 years,
now,
you have been going
now,
there.
my lord, they stopped the transformer, my lord, no connection, my lord. Although they removed
Malad,
not.
in June, Malad, the transformer has burnt. Now he is not permitting our main Malad for Malad, the repairing works to be carried on there. He is not permitting because he is claiming that if this is my land, I will not permit.
You first indicate whether it is that this transformer is for the purpose of transmission line or something else. Is
From the
WPC
transfer line
required
to ice cream factory, my lord, beside the land over the private respondent.
You
my lord.
file a report as
Fine.
to what is the purpose of installation of the transformer. It is for the purpose of one person's benefit or for the purpose of public at large.
Malad, my instruction is 25 families have been Malad, given catered Malad, the electricity from that transformer and one ice mill is also
Petitioner
run.
is aggrieved by the
You know. Wait a minute.
Huh?
Get
Dada.
অর্ডারটা কি নোট হয়েছে?
It is adjourned fortnight.
6 has wrongly appeared.
Lords.
Yesterday I appeared in this matter, my lord. Yes,
Yes,
you say wrongly appeared.
Yes.
Yes, Lordship, kindly.
So, well, Lordship, I am for the petitioner. Lordship, TST authority has been served.
We've not received a copy of the writ petition. Apparently, my lord, they must have served it upon the regional my lord.
But
Part-
that is how it is to be served.
But
The
if-
article has been made.
Now, TSC authority has been served. So, for the private respondent,
I appear on behalf of CSC.
TSC has been served. Lordship, so far the private respondent is concerned. Lordship, the track report showing not delivered. This is my service. This is a new electric connection to the shop room, which has been purchased by me.
Serve a copy on your learned friend.
Lordship, already CSC has been, I have served.
Yes, but you don't want expedition. If you can serve it immediately, then tomorrow I can take up the matter, or when the service is complete. If you are served at the regional office will give it to them, then they will come with instructions and all. Lot of time will be
No,
wasted.
I will serve. No.
Serve a copy. Henceforth, when you serve at their legal office, that will serve the purpose.
I have all, this is the service upon the legal office.
Not
It's Church Lane. Church Lane is the legal office.
Yes,
my lord, as for my
Church Lane I have served. This is the legal office, perhaps, Lordship.
Has been served.
but as for my instructions,
No, your instructions are wrong. Dekhan Didi.
Huh? Private respondent service.
See the stamp at the bottom.
Photocopy.
but in that
And
case, my lord,
district
kindly grant
engineer also
not
has-
today, my lord.
I'm passing an order since his affidavit of service is also not ready.
Yes, Lordship, kindly, only, Lordship, private respondent,
When did you send?
private respondent,
When did you send?
day before yesterday. Private respondent.
So it will not reach that fast. I'll keep it after a week.
Lordship, the kindly Friday, Lordship. This is a new connection, Lordship.
I know, but again on Friday also it will again be adjourned. Its service will not be complete. Likheni.
My lord, with regard to item 8, my lord, I am appearing on behalf of the petitioner, my lord, with regard to service upon the private respondent has not yet been completed, my lord. If your lordship kindly takes it up
Same
next week.
instructions, my lord, I've gotten, my lord, we've not received a copy of the writ petition.
CSC also says they have not received the copy.
My lord, it has also been served upon the office, my lord. I shall serve upon my learned friend also. my lord.
Please serve. Likheni.
No.
Since service on the respondents is not yet complete. This matter when after 1 week,
After one.
After one.
this matter on July 29,
Right.
2026, full stop. Service may be completed in the meantime. An affidavit of service He filed on the returnable date,
My lord, my lord, if possible, 1st of August, my lord, 29 I have.
August 1, 2020.
Great. Grateful.
August 1 is a holiday.
My lord, not August 1, my lord, 29th, my lord, 31st of July, my lord.
31st will be a Friday, difficult. 30th we can have it. 30th will be a Friday. 31st is a Saturday. 30th we can have it.
30th, my lord.
Okay. July 30.
Well.
Yes. Next.
Lord, I appear for the petitioner, Lordship. Here we have challenged an order of the Ombudsman.
Yes.
But I be accepted for the ombudsman lordship.
My Lord, may I file a, my Lord, affidavit in reply in the matter also.
What was the order that is impugned?
Private.
Order impugned is at page 31, Lordship.
Page 31. Yes.
In short, the matter is, my Lord, in 2006, my Lord, they made an application in an incomplete form. We immediately intimated that you have to execute an agreement. That was not done. In 2011, my Lord, by an interim order passed by my Lord RGRO, we gave connection. Then, my Lord, they and my Lord, awarding compensation was refused by the RGRO. They preferred, my Lord, appeal before the Ombudsman. Now, Ombudsman passed this order. Now, my Lord, we have challenged this order on 3 grounds. Basically, the application means it is defined in the Act itself. The application means not one making one application, one plain paper. All other formalities to be complied, then it is to be treated as, my Lord, Ombudsman. To that extent, my Lord, we intimated you are to execute an agreement. That is, my Lord, on record and not denied also. That was not done. And in this way, it was continuing, my Lord, till 2011, when they approached RGRO. RGRO said, my Lord, after hearing compensation part is gone, you are to give connection, you give connection in 15 days. We have given connection. Then, my Lord, he was not happy for not having, my Lord, compensation. Now this order of the Ombudsman is also bad in law because it is existing, it is, my Lord, settled position now. Before passing, my Lord, final order, my Lord, draft settlement order has to be passed and, my Lord, opportunity of hearing to both the parties to be given. If it is not done, even if it is given, thereafter also, my Lord, a time has to be fixed for filing their objection to the extent or suggestion, whatever it is. Then upon hearing again both the parties, a reasoned order has been passed. Here, my Lord, this formality is totally missing, thereby denying the principle of natural justice, which is, my Lord, settled law in the, it's starting from all the, my Lord, regulation up to from.
So show me the relevant regulation.
Lordship. At that point of time, it was regulation. Regulation, my Lord, regulation 27 was prevailing. That was 2006 regulation.
Show me.
My Lord, may I have, my Lord, may I have this. (9.5) Lord to kindly sees. 9.5, Lordship. The working procedure of the Ombudsman, I am not placing all. 9.5. Has your Lordship got it? After perusal of the available records in the form of the grievance petition, along with its enclosures, if any, and the report of the distribution licensee with its enclosures, if any, the Ombudsman shall pass a reasoned and speaking settlement order in writing within reasonable time after giving a reasonable opportunity of hearing to both the parties. My Lord, this has been more categorically, my Lord, mentioned and clarified in subsequent regulation also. My Lord, even before passing, my Lord, draft settlement order, in settlement order, both parties to be given the chance to, my Lord, place their argument, and thereafter, my Lord, final order of settlement, again, my Lord, fixing a date for hearing, and
the order to be passed. It is totally silent in this procedure followed by ombudsman. This is number 2. And number 3, for awarding compensation, kindly see the language I am placing, how it will be assessed. Because from this time to this time, I think you have not done, therefore you have to give compensation. Why compensation? Where is our fault? That has to be categorically mentioned. Some reason has to be given against us or in support of awarding compensation. Lordship, seize the order. Lordship, kindly excuse me. I am also placing the subsequent, the regulation 56. Lordship, have a look to this, then, I will come to them. How the explanation has been given. This is regulation 56, Lordship. 10.5. The working procedure of the ombudsman. On receiving the views of draft order, here it is also missing, no views was called for, no reflection for draft settlement order. As referred to in regulation 10.4, if submitted within the time limit by the parties or any of the parties, the ombudsman shall fix up a date and giving opportunity of further hearing to both the parties, following which he shall pass recent order. Here, draft settlement order has to be passed. Before that, also the principle of natural justice has to be followed. It is totally missing. Thereafter, final order. In final order also, the procedure is totally missing. Therefore, the parties have not been given, reasonable opportunity as prescribed in the Act itself, the regulation itself. Therefore, total denial of natural justice. And the matter should be remanded to, maybe set aside and to be remanded to the ombudsman for fresh adjudication. Now, the order. Now, see the order at page 31.
Page
31. Before placing this 31, may I please page 21. Page 21. Page 21.
Yes.
This is unable to why we were not in a position to provide connection. That we wrote a letter. What is it? We are very sorry to inform you that service connection cannot be provided against your service connection number such and such, dated 21/10/5, because although you have paid the quotation money, but you did not make any agreement, except this official formalities for providing new connection is not completed fully. That's why we are not able to effect the service connection till date. Today, 5/7/11, Mr. Tapon Kumar Mondal and SM Sonakhali Customer Care Center, Mr. Raju Vishwas, Assistant Sonakhali Customer Care Center, visited your premises to complete the above mentioned official formalities for providing the service connection. In this time, Mr. Anjan Kumar Durai, son of Kishore Kumar Durai, village such and such, came to the spot along with your documents and insisted you not to sign the agreement. Then you refused to sign the agreement. Now it is your decision whether you complete the agreement or take the service connection or not. Willing to take the service connection, if you will come to the Sonakhali Customer Care Center within 15 days from the issuance of this letter and complete the above mentioned formalities, then only we will be able to provide the service connection. Otherwise, it will be considered that you are not willing to take the service connection. This is a letter we have given, my lord, in support of the background of this delay and all this. This is one part. Then, my lord, kindly see also the application. He made an application, that's the contention. But what is the meaning of application? Lord, you kindly come to the Act 43, Section 43. Lordship. What is the application? After making application, steps are to be taken. What does it mean? Lordship, you kindly come to Section 43.
Yes.
43, my lord, the explanation. Lordship, kindly skip over 3 paragraphs. Explanation 1. For the purpose of this subsection, application means the application complete in all respect in the appropriate form as required by the distribution licensee, along with documents showing payment of necessary charges and other compliances. Now, my lord, at least up to that date, my lord, he has not completed the formalities, and there was no complete, my lord, form before the company, whereby obligation is to provide connection. So there was no obligation. My humble submission is there was no obligation to give connection, ignoring or forgoing all these formalities required under law. Now, lordship, see the order. That's the, my lord, last part of my argument I am placing. That's a page 31.
Yes.
The representation of complainant is in the manner the claiming compensation for delay in effecting domestic connection. An opposite party submitted report 18/7/11. After hearing the matter on 13/9/11, this authority passed an interim order for effecting the connection, and during hearing on 11/11/11, it was reported that the connection has been effected on 21/9/11. Now, the complainant deposited quotational money for the domestic connection on 21/10/5, and complaint states that he verbally reminded opposite party several times for effecting the connection, and finally wrote to opposite party on 22/5/10 in the matter. And plea of opposite party is that the complainant did not submit agreement and form for which the connection could not be effected, and the date for which complainant applied for connection was earlier to 19/10/5.
Mr. Nayak, I have read it.
Lordship.
I have read the order.
Lordship. And, my lord, here no reason, my lord, as to why this amount is to be paid. And, my lord, another point was given that earlier to 55, there was no quantum mentioned, so and so, so and so. And also the compensation part, my lord, maximum that is decided or any part thereof. So why any part, not part thereof, or why to not be considered? At least no reason has been.
Understand, any part thereof, part has only been considered.
My lord.
Part only has been considered. You have not been considered for the entirety of the period during which you were supposed to effect supply. Part has been considered.
No, amount, either this amount or any part thereof. This is what my humble submission is this, my lord, incomplete, and my lord, the order is not a total unreasoned order, and my lord, the dictum of the act that give us the opportunity for filing, my lord, and to hearing, fix a date for hearing, that is not given. If it is not given, so, my lord, this order is devoid of any merit, and, my lord,
Yes.
My lord.
justice.
But there are several aspects in this matter. I am coming one by one. The first thing is, my lord, my learned senior friend has stated there should be a draft settlement order before passing the final order. But the concept of draft settlement order has come through, my lord, the regulation 56. Regulation 56 has come into effect in the year 2013. This order was passed in the year 2011 when regulation 27 was in force. Now let us come to the regulation 27. Under regulation 27, my lord, the regular clause, I mean, it is 27. Clause 9.4. The ombudsman shall call for a report with the relevant details from the concerned distribution licensee on sending to the latter a copy of the grievance petition complaint under intimation to the aggrieved consumer. The ombudsman shall fix a time limit, the length of which will be decided upon by the ombudsman.
by which the distribution licensee should submit the report. The distribution licensee should be asked to send a copy of the report to the aggrieved consumer stroke complainant. After perusal of the available records in the form of the grievance petition, along with its enclosures, if any, and the report of the distribution licensee with the enclosures, if any, the Ombudsman shall pass a reasoned and speaking settlement order in writing with a reasonable time after giving a reasonable opportunity of hearing to both the parties. So, my lord, here, which is prevailing at the relevant point of time, was calling for a report from the distribution licensee instead of passing a draft settlement order under the regulation 27. Now, my lord, if your lordships kindly come to the order impugned at page 31, the first paragraph says, the representation of complainant is in the matter of claim of compensation.
Labor on this point I have understood that.
So, my lord, report called for and they have submitted the report.
Draft settlement order was not required in at that point of time when this order was passed.
And which was required, that has been, my lord, complied by the
A
Ombudsman.
hearing after issuance of draft settlement order was not required. That came to be incorporated in the regulations later in 2013.
Grateful lordship.
At that point of time, it was not the requirement of law.
Grateful lordships.
You answer me on this point. Take section 43.
Yes, my lord. Compliance of formalities.
Yes. If the expression application has been explained, for the purpose of this section, application would mean what has
Now, my
been
lord,
written
on this point, my lord, there are disputes, statements and counter statements. But what happened for that reason, my lord, if your lordships kindly see, look on the facts first. Lord, the application was made in the 5th of April 2005. Quotation was issued on August 2005 and quotation was deposited on October 2005. Since October 2005, no intimation from the end of the licensee to the consumer that he is supposed to.
The application form. Does the application form indicate that an agreement is to be entered into? How will the consumer know?
But that is not in my custody, my lord. I cannot answer.
How will the consumer know that the application form would be complete only upon an agreement being executed, because that is not the requirement of the statute? That may be your requirement, the licensee's distribution licensee's requirement. Now, if that is a requirement which is internal in nature, then in that case, a consumer who has applied may not be able to know it because it's not there. If it was a part of your application, the application indicated that upon payment of quotation and upon execution of an agreement, you will be entitled to electricity. Then in that case, you have a point saying that no, this application is incomplete. It does not answer the test of section 43. But till such time that you are able to demonstrate that this was across the knowledge of the consumer concerned, since the statute is silent on the nature of the application that can be, since it is your baby, you have to demonstrate that
My lord,
would mean
my
what
lord,
you want it to mean.
Yes, I bow down, lordship. Now, my lord, in the act, it is said as per the form.
Right. So that is why
The form is
from which it will appear that the agreement was a necessary appendage to the form. The agreement.
There was no, my lord, at least no the mentioning of form was filed. Form was in the form prescribed form.
No, but then how will Mr. Nayak? You can innovate then at will. You will innovate a case saying that no, this is also required just to fill up the lacuna, just to cover the delay. Now, if this is a case, we have to think it in that term also. The consumer will have to be put on notice that these are requirements which have, for example, you issue a quotation.
It's too old.
Suppose you did not issue a quotation.
I bow down, lordship. I will not argue against it. I will certainly support it because my conscience also says that this may be required. But it's a 2012 story. Now, my lord, record, it will only beyond the record, it is not possible, should not make any comment. I will not make any comment. What is on record? I have to go by the record. I cannot create any record. So, my lord, how it was, what is the application form? That is the only solution. If you can produce the application form available, then everything will be available therein.
Produce it.
My lord, at this moment, how? I may not answer it. Because 12 record.
No, but since your argument is that the application form is incomplete.
It was not disputed at all because
Mr. Nayak, in the scheme of things, that is the only argument that can allow you sail through this case. The first argument will not hold water because
well, that's
there.
But before Ombudsman, they have not taken this point also.
Not required. The Ombudsman has said that you have not informed. This is the meaning. Once the ombudsman says that you have not informed that you are
No, no,
required
I am
to-
not saying that, not information. Whether it will be a plain paper will be the application or a form with the application.
No, even if it is say it is on a plain paper, that is not your case also, that the application was only your
And in
plain-
this way, it was not placed.
This was not your case also, that it was on the plain paper, that therefore we have not accepted it. Your case was that it was an application fit for issuance of quotation. He pays the quotation, you accept the quotation. After having accepted the quotation, you keep quiet for 7 years. Then you suddenly issue a letter saying that you have not filled up an agreement. You are required to fill up an agreement. Now, these 7 years during which
And consumer replied to that letter, Lordship.
supposed to fill up an agreement, how will he come to know that there is an agreement in existence which is required to be filled up? Either it has to be indicated in the application or it has to
No,
be
I
indicated
bowed
in
down,
the
Lord, that I
quotation.
appreciate.
Where is that? How under the sun will he come to know that this is one more requirement that I have to fulfill, without which even after having paid, I will not be blessed with a connection? How will you know that?
Oh, my lord, that I cannot escape this point.
That is the only point now to answer.
No, other point is also very, I will
What is
place
the
it,
other point?
because where is the point of hearing? Because very well, I have given the report.
No, then Mr. Nayak, the draft settlement order or the order that has been passed, which has been included in the writ petition, that is an
No,
order.
final order.
Yes, it is a product of hearing. It is not that you have not been heard before this order. You are only required now. The dual hearing concept has been introduced in 2013. Before that, there was only one hearing. Here you have a hearing, draft settlement, another hearing if you object. Otherwise not. Here there was only one hearing.
But here, lordship, we know the hearing part is also missing. It was heard after submission of the record. We have placed our record report, and thereafter hearing has been taken place. I don't find it subject to correction, lordship. If it is there,
Is it your case in the writ petition that you were not heard? Or that is your submission from the bar? Show me the averments in the writ petition that you were not heard.
Where it is stated in the order, after hearing the matter on 13th September 2011, this authority passed ad interim order, and later on, after effecting connection, during hearing on 1st November 2011.
Okay, so
During
first-
hearing 1st November.
1st November, the order was passed. On that day, you were heard. Just I'll come to you, Mr. Samant.
so my lord, as against my lord's first question, may I consult the record or ask for the record if any?
Come back. But that is the only question which you need to answer.
No, that is my lord is putting him. Obviously, I cannot escape because what is on record. If it is not there, how can I? I cannot improve it.
Yes.
And my lord, rest part I will be placing after satisfying this issue. lordship.
Page 27.
Before passing this order,
That has been shown.
there has been 15th of July 2011 to the ombudsman.
That is the report,
And,
Lordship.
the recognize all the facts as stated in the order.
Very well.
But I shall show one more letter from the end of the consumer. In reply to their first letter intimating him that you are supposed to sign an agreement. That is a space 22. Consumer is saying, I have complied all formalities long back. And don't ask me to repeat the same. Once again, filling up any further agreement. That has been replied by the consumer, and they have not replied to him that this is wrong or something else.
No, reply against reply is not required. If form is there, no, that will speak for everything.
But after the letter which you issued in July 2011, did he execute another agreement?
No, because court directed you give connection. We had to.
Where is that order by which court directed?
National Commission, my lord, the first paragraph of the impugned order.
Oh, by the ad interim order.
Yes. So that has to be, that we complied that. Be that as it may. Now, my lord, one thing is also very important. Lordship will have to maybe please to consider whenever a compensation is being awarded, then my lord, reason has to be given that why this amount.
Mr. Nayak, you are well aware that these are quasi-judicial authorities. If reasons are available on the record, merely because he has missed to incorporate a reason, his ultimate conclusion is right. As a writ court, I will check only the decision-making process, whether he has complied with the formalities or not. Ultimately, whether the decision is absolutely sound or legal is not the test which is to be put on the order which has been impugned before writ court. You are before a court which is judicially reviewing it. It's a judicial review jurisdiction,
My lord,
not an appeal.
I am not denying anything. I am not denying anything.
We can
Only thing is this, my lord. Only, only
that is, because that is
only thing is this,
that
my
is
lord.
the biggest stumble in
How
your
these matters are being dealt with, and my lord, lakhs of consumers. Why there is delay in, my lord,
and then you have
rural-
to overhaul your process so that at the first go introduce an appendage to the application to do list. These
My
are
lord,
the formalities that are. If
why
you
it-
do not educate your
why it
consumers,
happened and why was it was
I will
not
also
happened?
be able to know. If you ask me to fill up a
My
form,
lord,
I'll fill up a
I-
form. You
I-
give me a
I-
quotation, I will pay the
I
quotation. Then
cannot-
whether I have to execute an agreement, what will be the format of the agreement? How will I know? I have to be informed about it because
Let me-
that is your internal arrangement. If it was by way of a schedule in the act, I would have understood that yes, in terms of appendix 1 to the schedule, this agreement has to be executed.
Executed.
I would have understood that.
No,
is not
only
there.
thing is this whether there was any prescribed format
every
or not.
distribution licensee will have different formats. How will the consumer know?
I will.
Mr. Nayak, learned advocate. হ্যাঁ একদম একটু আলাদা করবেন না।
But I am for the petition. Your lordships, my lord, took up this matter on earlier occasion. But
The claim, my lord, out of electrocution, after 2 years, my lord, of the incident, my lord, the complaint was lodged, my lord, to the authorities, my lord. And that is why, my lord, your lordship was pleased to direct, my lord, to see whether there is any judgment to that effect, my lord. Spend a short time for judgment.
my lord, I have brought the judgment. My lord, kindly visualize one thing. My lord, kindly see my representation. My lord, that is at page 15 and thereafter, my lord, page 16, my lord, is the relevant portion. My lord, may I read it for your lordship? Page 16. 15 is the, my lord, starting page.
Page 16.
My lord.
Yes.
My lord, it is in Bengali written. My lord, গত
24/10/2021 তারিখে সকালবেলায় আমার একমাত্র উপার্জনশীল পুত্র দেবাশিস গিরি আমাদের নিজস্ব জায়গায় কৃষিকাজ করাকালীন সকালবেলায় বিদ্যুতের লাইন ছিঁড়ে গায়ে পড়ে। আমরা তাকে পরবর্তী সময় হাসপাতালে নিয়ে যাই এবং ডাক্তারবাবু তাকে মৃত বলে ঘোষণা করে। Malad, there is a allegation, Malad, by the petitioner that the live wire was fallen to his body. Malad, what is the Malad? They have inquired after 2 years. Malad,
Because your complaint was after
Malad,
2 years.
Malad, kindly see the nature of the Malad inquiry. Page 7 of the opposition, Malad.
Page 7.
Malad.
Yes.
My representation is of Malad 8th April 2023. They have conducted the inquiry, Malad. The report is Malad 16th May 2023.
Yes.
That is addressed to the officer in charge, Malad Ganganagar Police Station. Malad, neither Malad 161 of the Electricity Act, Malad, has been complied with. They have not Malad reported to the Malad inquiry report to the Chief Electrical Inspector. Another thing is this, they have.
But after 2 years, how will it help?
Malad,
in
it
any
is
case?
corroborated with the Malad postmortem report.
Postmortem report will show that he has died due to electrocution.
Malad.
How did the electrocution happen will not be reflected in the postmortem report. Whether the electrocution was by the result of what they say that you were charging Toto on a wetland or because of a live wire snapping and falling on you. Now, this will not be reflected in the postmortem report will show the immediate cause for injury. But the reason which caused the injury would not be indicated in the postmortem
Malad,
report.
this honorable court, Malad, on earlier occasion, Malad, kindly see the judgment of Raju Sheikh, Malad, coordinate bench of this honorable court. Malad, kindly see the paragraph number I have mentioned.
Yes.
Malad, kindly see the paragraph 31, page 7 of the judgment. At the footnote of the postmortem report, it was specifically written that death was due to the effects of electrocution, as noted herein above, anti-mortem in nature. Nothing is produced to rebut such specific finding in the postmortem report to dispel the presumption of death by electrocution. Thereafter, this court thereafter, the WBSCDCL also went up to the division bench in this matter.
The paragraph 22.
My lord,
And report my lord copy.
Hand it up to him.
my lord. May I read it for your lordship thereafter?
No, I have. You
Well.
give it to him. The paragraph 22.
একটা copy আছে?
This is dangerous for you.
Yes, but my lord, if it is cost, factual aspect may be different. My lord, if it is cost at the instant of my lord, the victim.
There is another observation. Kindly see paragraph 32. Irrespective of negligence, whether it was your negligence or not, since it is your property, you are responsible is what has been held.
The Honorable Division Bench also confirmed this. Affirmed this.
To my lord, 32.
You want to consider it, come back, you can come
Yes,
back.
my lord. Let me come back, my lord, day after tomorrow, my lord. Or my lord,
Not day after tomorrow. Day after tomorrow will again be Friday. Come back next week.
next Tuesday, my lord.
Next.
Give me that.
Division Bench.
আমাকে একটু একটা কপি দিন। ডিভিশন বেঞ্চের
ডিফিকাল্টি
এমএটি নাম্বারটা কত?
এমএটি নাম্বারটাও তো ভুলে গেলাম। আচ্ছা তোর কাছে?
এটা রাখো। এমএটি নাম্বারটা আমি তাহলে বলি। এমএটি নাম্বারটা কত? আমি দেখে নিচ্ছি।
5 lakh compensation policy you have.
Yes, that I have.
Why don't you consider paying that?
But my lord, liability has to be fixed first. This is to be done by chief electrical inspector, who is not made a party.
But then in this case also the
Representation.
After 2023 when the representation was made, you
Yes.
also ought to have approached.
Yes, but representation was not made to the chief electrical inspector.
Here also it was not made to the chief
Chief electrical inspector.
Normally the records are sent. Normally records are sent. My lord, what I am on.
Have done it. You should have done it.
Well, I have to take my whether this has been already communicated to them or not, my lord. Let me come back.
Come with the information then, because you have already used an opposition. Have
Yes.
you not stated?
No,
that?
no, I have not stated. I have not stated.
My lord, they have.
Instruction probably had not with me at the time when I drafted it. But even then, my lord, I will take instruction. Whether it is lying with my lord, chief electrical inspector, my lord, task will be easier.
In the report also. My lord, reliable sources and the my lord, they have stated
একটু ম্যাট নাম্বারটা দেখি, জাস্ট ম্যাট নাম্বারটা একটু দেখে নাও।
in presence of the local witnesses. Who are the local witnesses? Nothing has been disclosed in the office.
ওটা রেখে নেবেন আবার। Next.
Grateful judge.
But I am for the rest. 11, my lord, I am for the petitioner, my lord. On the last occasion, my lord, your lordship, my lord, gave me a liberty to file a reply, my lord. My lord, reply.
Just now I have received it.
11 এর ক্যানটা দেখাচ্ছে না কেন বারবার? ক্যান থাকছে, আপনারা ক্যান দেখাচ্ছেন না লিস্টে? সেদিন কেউ ক্যান ছিল না, আজকে আবার ক্যান লিস্টে নেই।
ক্যানটা বোধহয় রেস্টোরেশন।
বলতে হবে লাস্ট বার ওটার জন্যই কাটা হলো, আবার এই একই জিনিস হচ্ছে, তো ক্যানে অর্ডার পাস হলে কি করে আপলোড হবে? জানিয়ে দিন, not today, come tomorrow.
Well, the
10 is not in the list again. এটা বারবার
application টা জজ সাহেবের লিস্টে আসছে।
application কিসে?
Restoration টা।
That was allowed.
না অ্যালাউ হয়নি। ওটা জজ সাহেবের লিস্টে ছিল না বলে আজকে আবার লিস্ট।
Oh, restoration. If the can is not shown in the list, the order will not be uploaded.
Yes, yes, madam.
It has to appear in the list first. বলে দেবেন যে লিস্টে দিতে।
Restoration হয়নি? মানে the reply, মানে should I take
Now
it
you
back?
take it back. Next.
এই restoration হয়নি? না স্যার আগের দিন হয়নি। জজ সাহেব বলেছিল ক্যানটা আজকে লিস্টে দিন। রেস্টোর করে বলছি।
Please, Lordship, I am for the. No, there was a direction to file a report, my lord. We have not received.
Report for what?
This is an application.
Willing to shift or not?
No, we are not, madam. We have found an alternative space, madam, which the petitioner is not agreeing. Madam, kindly come to annexure 7 of the report, annexure B, page 7, madam. Madam, there are 3 arrow marks, madam. First is the existing transformer. Madam, we kindly see on the left hand side, there is a newly selected position for shifting of transformer. Madam,
You've not given him a copy of the report.
Yes.
Yes.
Madam, what has happened, madam? This transformer, existing transformer is there from the year 1986. Madam, there were joint inspection, madam, which has been carried out firstly
And
by.
where does he want?
Madam, he wants to remove it. He wants to remove it. We have
And
found
we'll
that
bear all the cost.
it is not possible because, madam, there is a space shown. Madam, kindly see this portion. There is a space shown by the petitioner. We have done a joint inspection with the KMC. Firstly, madam, this is not technically feasible, and if we put it here, the whole locality, it will be under jam-packed situation.
The transformer is in his building.
Yes, madam, kindly come to page number 5.
When was it installed? 85.
86. It is in a separate position, totally safe. Page number 5 is the photograph annexure A. Kindly see the page number 6, that is the internal arrangement. It is totally clean, totally safe. Now he wants to remove this.
Why was it installed there at the first instance?
He is a subsequent purchaser of the property. In 86, when we purchased, the landlord allowed us, and it is for the total locality, we are putting. Kindly see the report, my lord. The page 2, paragraph 2 onwards, my lord, the existing transformer is very much required to meet the growing demand of electricity and to provide steady supply in the area. The said transformer space is 5.6 meter by 5.3 meter width of the road from the transformer boundary wall is around 4.8 meter.
You have given a copy of the report.
Just
Mr.
now.
Haldar,
My lord, kindly allow me for a minute. My lord, petitioner purchased the property. He is a doctor. And his son also a doctor. For that, he wants to construct a
clinic.
That is the whole problem. And my lord, kindly see how much they have acquired that land of 400 square feet. My lord, kindly see how much they are paying for the page 11.
Page 11
of the writ petition.
Page 11, yes.
The amount they are paying for that plot, 25 only. Mala, kindly see middle of the amount of that paragraph. Only 25. Mala, have this page 11. Only they are paying us.
Mr. Mukherjee, why don't you increase the rent then?
I have to take instruction.
Well, not only that.
This is the first time it has come up.
No. In all the matters, it has been hard, and for that they have not taken any step first. Secondly, just just in front of the premises of the petition, there is a space. They have inspected, photographed it. We have page 25, just in front of the 35.
This we have marked it in page number 7 of my report, my lord.
Page 25.
35. 35.
Page 35.
35.
Yes.
That portion is vacant.
Page 35 is an order sheet.
No, that is 25. And 24, this is the place we have marked. This transformer can be shifted that portion of 24 and 25 in the writ petition. Just corner plot, but it is in front of the premises of your petition.
Is this a very busy road? What is the problem?
My lord, kindly come to my report.
From
Page
the
number
photograph at page 24, it does not appear to be very busy.
My lord, kindly come to page 24, page number 2, last paragraph. We have dealt with it of my report, and my lord, we kindly tally it with page number 7 of my report. My lord, what we have seen, it is further stated that during the joint inspection, the Kolkata Municipal Corporation official assistance was also taken. It has been advised by the officials of the Kolkata Municipal Corporation that they have strong objection against shifting of the existing transformer at the corner portion of 16 feet wide common road as suggested by the writ petitioner. They also suggested that local people will have access problem if the existing transformer is installed at the corner position of the road, irrespective of the shortage of space, and moreover, vehicular movement will be hampered. It is also been specifically stated that the instant road is connecting Joka to Thakurpukur, and for maneuvering the VIP movement and also public vehicles, smooth access to the road is very much necessary. The installation of the transformer at the space suggested by the writ petitioner or anywhere in the said road will shorten the space of the same and will lead to severe traffic congestion.
In front of that
is the reason, my lord, we have already indicated a newly selected position.
And there is a pole also of the CSC in front of that.
Poles are not of CSC, my lord. Otherwise, we would have written, my lord knows it. It is probably of the KMC.
And my lord, the front portion of the land is a graveyard. So
my learned friend is saying we will obstruct the entrance of the graveyard.
No. It's the back portion, not entrance. This is the back portion of.
You have seen page 2 and 3 of the report. It says that it will require 4 feet by 4 meter by 4 meter.
That is more than sufficient.
If it is only 6 meter wide, then only 2 meters will be left for vehicles. That will be difficult.
No, Mala, kindly see the position of that portion. Mala, kindly see that road it will not be blocked.
Photograph, see page 3 of the report. The page 3 of the report says that 4 meter by 4 meter will be required.
Yes.
And 6 meter is the width of the space.
Yes.
So what will be left for vehicles?
Vehicles, Mala, kindly see the road. This is far away from the road.
Take an exception to the report on affidavits. Let us see. We'll fight it out then. Fight out.
I'm getting
May I please your lordship, my lords?
Item number 13, Dr. Murthan sir is appearing for on behalf of the CSC manner. He is only at code number 25. Manner, can you pass over the matter?
Pass over.
My lord, pass over means it will not be started.
Not
Huh?
today,
Kindly take it up tomorrow then.
not today.
Let it retain its position because there is some urgency and the disconnection, my lord. Yes, I'm grateful.
Time for the petition. The petitioner purchased property from the previous owner, and we have annexed the deed. And we got the position, that is annexure P2, page 13.
Yes.
We have got position on 21 February 2025. And on that same day, they have disconnected the electric line of the previous owner. Now I purchased that land, property, and the demanded of rupees 5,29,404. Am I?
Let me I submit.
Am I?
Petitioner was found deriving electricity wrongfully, illegally, my lord, from the incoming phase loop of the disconnected meter in the name of the previous consumers, and my lord, whose connections were disconnected due to non-payment. And my lord, if your lordship takes up my report, my lord, and comes to page 14 of the report, my lord, he has categorically admitted that, my lord, the unauthorized that he was not enjoying electricity, and, my lord, he was aware that both the meters were disconnected condition and was planning to reconnect them by paying necessary charges, but could not do so due to personal reasons. Request for favorable consideration of payable charges. Page 14. So, my lord, since admittedly, since admittedly, the position is that petitioner, being without electricity, was found deriving by tampering the meter of disconnected meters, my lord, he was caught and this bill was raised. And, my lord, subsequently, my lord, the amount was reduced after hearing, and it was made, my lord, 5,830,000 only. This is the position, my lord.
Mr. Haldar,
First-
you have derived electricity from
No.
disconnected meter.
That is the first day we entered the premises.
So you could not have derived it from a disconnected meter.
No, that cannot be the first day, because, my lord, they received possession on 21/2, and, my lord, purchased the premises on 16/2. They have purchased the premises on 16th of February.
Okay. মানে this is
This order of provisional
থাকলে আমি তোমাকে চাইবো
আচ্ছা, নিন।
My lord, kindly
When was the order of provisional assessment passed? May 25.
My lord, provisional assessment was passed on
May 25. 21st May 25.
21/5,
Yes, so it was 3 months.
my lord.
the letter just produced by my learned friend.
I have handed over this instruction long back. না,
আমাকে একটু বলতে দি লং ব্যাক হলে
just
আজকে
produce বলছেন কেন তাহলে?
আজকে হিয়ারিং হচ্ছে তো
Just
তো
produce.
কবে দেখাবো আমি is not written by the petitioner. Mala kindly see.
Maybe. That is not
Tara-
usually written. That is the custom.
No.
That is the practice.
The
The petitioner
accepted
who can write in
is-
English, petitioner who can write in English can easily read what is written there.
Mala kindly see the handwriting is
It is
not-
already there.
আরে দিতে হবে না।
আমি দিয়েছি। Page 14, where he has admitted about of my report, my lord.
There is no report.
My lord, I have submitted the report on 26/6/2025. Anyway,
No,
এটা- এটা-
26/6
Say
only
to Eli.
says all documents be supplied to them. There is nothing on.
my lord, it is there.
Mala kindly the handwritten and the signature.
They are never typed. They are always handwritten.
are
as-
different.
After perusing
They
the
have,
same, they sign it.
they have made this.
You prefer appeal, Mr. Haldar. You take these points before the appellate authority. What is the problem?
Absolutely.
Take these points before the appellate authority. Will be
That liberty we give him. That liberty we give.
the order was passed. But he has filed it within the period.
So within 7 days, it will clear. Otherwise,
If the
Fine. Grateful.
earlier order also does not record it.
Grateful.
You want me to record that? This one.
Not required.
ठीक है नहीं? A is what for?
Yeah,
May I please your lordship?
Your lordship, I beg
Well-
to appear on behalf of the respondent number 8.
Well, respondent number 8 is a private respondent. Allow me to proceed with my matter.
My lord, the difficulty is that this
Well, he does not
property-
have any right of audience at this moment. Allow me to move my matter. Then he's a borrower who has in section 14 order obtained, district magistrate took possession, handed over. The borrower thereafter barged in, break open the padlock, went inside, took back possession. We lodged FIR, charge sheet has been filed. Now, my lord, thereafter we have written to the district magistrate to reinforce the section 14 order again. My lord is very well aware that, and I am fortified with several judgments which says that the district magistrate can, in such situation, reinforce. My writ petition is limited only to that extent that direction may be passed upon the district magistrate to reinforce this.
Lordship, I appear for the state.
Yes. My lord, this property is a family property. It's a joint property. I am one of the co-owners. My lord, what they are claiming is right from through some.
Yeah, you challenge the order, but district magistrate has to reinforce
My
that.
lord,
If
the
the order was
proper-
passed, you could not have violated it and
My
entered.
lord, I am not a borrower in the matter. I haven't taken any money from the bank, and it is a family property. Whether any
Then
fraud
why are
has
you made
been
a party?
committed,
If you are not a
whether
borrower,
there
why
is
have you made him a party?
Well,
It's
in charge sheet, their name is appearing. The police has completed the investigation and charge sheet has been filed.
My lord, I have
My lord would kindly see the charge sheet as page 65.
bringing
Where
a
is the
record
scope?
chain of title, my lord. Because, my lord, this
Let him go to DRT and file a
lord,
section
this
17
response
against my
is-
orders.
My lord, I cannot have because there is no cause of action to approach the DRT right now under section 17, my lord. My lord, what they are claiming
Why
is-
don't you have?
My lord,
Any
they are
person
claiming
aggrieved by
right
the order?
from the
You are
response
any
of 6
person
and
aggrieved
7.
by the order. Why don't you have a cause of action? You are any person aggrieved by
My
the
lord, there
section
is a
14 order.
limitation, my lord. They are asking.
Limitation, you say
Now,
whatever
my
you
lord,
have
they
to
are
say.
claiming their right from the response number 6 and 7. My lord, this property is
The order, show me the
our
order.
My lord,
property,
my lord, the section
And
4,
disputes with regard to my lord
Section
title
40
and my lord the
section-
petition hasn't been affected.
section 14 order is at
Family
page
property, my lord.
46 and the
Page 46.
46 is the section 14 order. Possession handed over on 28 November, which is at page 50.
My lord, whether the property that has been they have taken
All this
possession
will
of-
be decided, all this will be decided by the DRT. I am not deciding anything here. The DM will reinforce his order. He has power to, authority to implement his
whether-
own order.
with-
You cannot stand in the way. Your
My lord,
submissions
whether
are not
the-
cutting
whether the-
across
Whether the
anything.
loan has been obtained by way of fraud or not, my lord. If a
That
party
this
says-
court will decide in this writ petition. Is it your petition?
My lord,
You cannot resist this.
whether I am the
Sir,
rightful
have you
owner,
not
whether
heard?
they have the
I
right
think
to
I have
take
made
the
myself
possession, that has
sufficiently
to be
clear.
decided, my lord.
I think I have made myself sufficiently clear. Merely because you go on repeating your things,
My
you're
lord,
not going to
I'm
make any.
not saying that. I'm not saying
Because
that.
then
My
stop,
lord,
please
the
stop.
thing is that
Please stop. It's not going, not cutting any ice at all. He is seeking implementation of the order passed by the district magistrate, which has allegedly been violated. The only order which is being passed is on the district magistrate to implement his order in accordance with section
My lord,
14.
I'm
What role do you have to
I
play
am the
here?
rightful owner of the property.
So you
I
take
am
these
the
steps,
rightfully in
whatever
possession
you
of the property.
on your assertion. Will I stop the district magistrate from implementing the
Kindly
order?
allow me to use an affidavit
Why?
bringing on record
You
my
don't have a
title
locus
documents,
here.
my lord.
No.
Whether this person
No,
has
sir.
any right to mortgage the property, that has to be looked into.
You should have
once.
you should have taken it.
My lord,
You
kindly
should
give
have
me that
taken it at the time.
opportunity, my lord.
Mr. Counsel,
Lord.
if you are aware of the law, the one section 14 order was passed and possession was taken. Why did you not challenge it? Why did you not challenge? This is only a consequential order. You should be aware of the law that if the main order is not challenged, you cannot challenge the consequential order merely because you know how to argue. Please stop.
No, lordship.
I have said whatever I had to say. This is enough.
I didn't know, my lord. How can I?
You didn't know and you barged in.
My lord, if I am a borrower, definitely they will come and send me a
Please,
notice.
yes,
that
tell
come
me
to know
the
with my application, my lord, the plaintiff in the suit for protection of his tenancy rights, my lord, repair petition filed way back, my lord, on 19th of August 2025, that has not been disposed of, my lord. Water's gushing in, my lord, through the roof, my lord. My business is at jeopardy, my lord. My lord, repeated adjournments have been taken, my lord. Kindly seize the dates of adjournment. That would be 26th of February, 22nd of April, and 19th of May.
Your petition for vacating.
Repairs, my lord. Affecting repairs to the suit property, yes, my lord. That would be, my lord, what page request?
Why is it pending?
Lord,
why is it pending?
They are taking adjournments. The defendants are taking adjournment. My lord, once I filed the suit, I got an injunction.
The application date 19th August ছিল
That will be 13th of August.
13th August.
And the suit
for the petitioner, my lord, that the order impugned, my lord, is perverse, and my lord, as well, it's more of it's inhumane. I'll show why. My lord,
And for the KMC, Lord.
with the petitioner is working as a handmaid, my lord, maid as a housemaid, my lord. She's staying there. She's staying there, my lord, for last 60 years by through her predecessors, my lord. Her husband passed away. Husband was the last recorded tenant. These are 120 square feet. We'll have a room on the roof. We'll kindly have a look. This is the page. Just a moment. Page 17. But this is a 17. So this is the application filed by the owners of the premises against this person for the increment in the fair rent. The fair rent proceedings. We'll kindly have a look. Page 17 is the proceedings. When it kindly comes to the schedule. The schedule is page and I'm sorry, my lord. Page 18, not the schedule, but the first paragraph. The second paragraph, third paragraph, my lord. Very sorry. Page 18, third paragraph. The opposite party was inducted a monthly tenant by the earlier landlord, but I'm staying there since 50 years. This is a story of 2011. For 10 years, early in respect of one room for residential is situated on the second floor, that is the roof, measuring about 120 square feet. Since 1950s, I'm staying there. All of a sudden, in the year 2024, I receive a notice under 544, 546 of the KMC Act, stating that this building this shed has to be removed. It's a room with a tin shade. When I don't find what was the reason, but there was no order, we'll just find the notice to remove. When I go to the executive engineer, I ask for a certified copy of the order. So what order has been passed against me? Will I get a certified copy? I see there was an order passed that some illegalities were detected, that the shed was illegally constructed. And so there was a telephonic complaint by a gentleman, I don't know who. Somebody complained, the KMC did not even come to inspect. They said that this is a 120 square feet of illegal shed and you have to remove it. Well, I filed the appeal before the building tribunal. In the building tribunal, I alleged 2 points, that I am a tenant in respect of that property at least for 50 years now. The minimum construction that can be there is a shed. Nothing below to constitute a premises. But I also say that I did not get a notice. I never received a notice of the 401, the proceedings under section 400, or the hearing notice, or the order passed. I was never served with that. Only on 541 and 546 notices were served on me. When the CR comes, well, I saw that there are postal receipts, but at those, there is no track report, and there is no indication that I have received. Well, still, the building tribunal proceeds and ask me to demolish the property. That 100 square feet. That's the only place I have. That's the only and impose a cost of 10,000 on me.
Yes, Mr. Das.
I have the record. If your lordship actually, my learned friend is not placing the judgment passed by the tribunal, which is challenged before your lordship. It's a very reasonable, reasoning is there. The only thing is this, my lord, the person who is residing there, he has been given 401 for stop work notice. He has not, the petitioner is not actually stopped the work. That may be that the tin shaded and other iron bar that is come under the heading of building, no doubt. And that is a very reasoning, the order passed, judgment passed by the tribunal is a very, reasoning is always there. And my record shows the petitioner went there for attending the hearing. One and two times, I have the record. And he appeared before the executive engineer, the first court, that is who is hearing the matter, and passed the order. Basically, the petitioner is a tenant. And now when he is actually constructing 401 for stop work, he is not stopping. And thereafter order passed, challenge before the tribunal. And my lord, my record shows regarding the natural justice or hearing that was given. Now the question comes regarding the legal, what is the legal standing? Oh, that is a challenge before the tribunal is executive officer has no power to pass the order. And your lordship, that is section 48 of the KMC Act, specifically actually giving the power for delegation upon the commissioner. Now that power is actually enjoying by the two limbs of the corporation. One is, my lord, that is special officer of building under 40 subsection 1, 400 subsection 1. Another is that executive engineer, actually so many voluminous work, executive engineer is also given by a circular, by 2-3 circular, that he can detect the unauthorized construction, issue the notice and take the initial hearing for demolition. I have that, my lord, that is in my mobile.
Circular 24, circular 173.
My learned friend knows 173 and 24 executive engineer has the power. That is his main challenge before the tribunal.
No, that's not my main challenge. My
The
main challenge
one
is
of the
twofold.
count is there.
One is that I never received any notices. He cannot show that there is a track report or even a written envelope showing that I have received or I have not received. And second is that I never attended the hearing. I never got a notice.
To show that he has received notice.
And kindly see one more thing. There is a D-sketch map.
You were not represented before the tribunal.
No, tribunal I went. I challenged that order. When I get the certificate, I challenge that order. I say to the tribunal that I was not given a hearing in the before the executive engineer. But that is what
the executive engineer's order.
Executive order is attached. It's at the
page.
Let's Xerox copy just before the certified copy. This one, just before the certified copy. Because I had taken a leave, and I did not get a certified copy of it. It's a stereotype order.
No, here is the
half-page stereotype order, no findings, nothing.
One.
I mean, may show you. PR absent.
Mr. Das, you file an affidavit bringing on record notices to show that he has been served.
He has been served.
There is only, I can even see there is only postal receipts, no track reports.
That is
why you demonstrate service until such time. Please don't demonstrate.
Only that.
I am enjoying an order of stay. I'm enjoying an order of stay that has expired.
They may be given. I will actually file.
But I have what I indicate.
Enclosing all the documents.
Only limited stay may be given.
Yes.
What I say, I was enjoying a stay till yesterday. Yesterday I filed an application. Yes, I filed an application. That is what it is. The CAN on record. CAN 1. Is the CAN.
There is no CAN on record. Yes, CAN 1 is on record. Didi CAN 1 ta diye din? Likhe
Well, what I indicate only this the client belongs
Lord, my application, Lord. Lord, very short point involved here. Lord, my learned friend has filed a suit in the Barasat court seeking specific performance of not a shareholders agreement. His allegation is that that draft shareholders agreement has been not apparently agreed to by us. That's the allegation in the plaint, and he's asking for specific performance of that along with consequential relief. Now, Lord, simple point here is Lord, under 2C 16 of the Commercial Courts Act, 2C 18 rather, Lord, of the Commercial Courts Act, Lord, a shareholders agreement is Lord, it's fully covered. It's a commercial dispute. Share purchase agreement is covered by 2C. Now, Lord, given that there's inherent lack of jurisdiction. Now, we have filed a Order 7, Rule 11. They are seeking to move an injunction application today. Lord, one of two alternatives, not either, Lord. I was looking for an order that the Lord, lower court Lord, decides the question of jurisdiction before Lord, considering the injunction application. Lord, this is one possibility. Second is, if he wants this decided in this forum, Lord, your Lordship will simply say,
because it has to be.
I'm not getting into it. That may be one way out, but Lord, this is the situation.
Mr.
Lord,
Mitro, jurisdiction has to form an opinion on the jurisdiction in any case.
Lord, just, Lord, I'll just take two seconds only, Lord, more.
What I'm going
But
to
if I may
submit,
just,
Mr. Bachawat can't oppose, so that's what I'm saying. But on 1st of July was a forfeiture notice, forfeiting my 20 crores of rupees. 7th of July, I filed a suit in Barashat court. We thought there was no caveat because notice was not served. We go and find there is a caveat. So the court fixes it today. They have filed the revision and Order 7, Rule 11 under the Commercial Courts Act. I am convinced with Mr. Bachawat's argument. I accept it. Let the plaint be returned immediately because of the urgency. I will present it for the commercial court. I accept it. That's why Mr. Bachawat can't possibly.
Done.
So we'll do it here, or you
Lordship, kindly make an order. Kindly make it because of the urgency.
Can't be done.
Here it
Lordship kindly makes an order. Otherwise, well,
no, you go and pray it today itself. It is fixed.
Yes, your Lordship
kindly
records
make
the submission.
Make an order.
The Lordship records the submission.
Make that order that you will make that prayer and the
And then on an urgent basis, I will take it back. Lordship,
yes. If you can make a prayer for preponement for today itself and you file an application.
No, today at 2 p.m. it is there.
No, very well. Then I'm making that order. লিখে নি এটা সার্ভার করে দেবেন তাড়াতাড়ি he agrees you don't have jurisdiction. Now, after that also, retain jurisdiction. That's very,
court has not gone into.
Well, in that case, my
That
juniors,
confusion is allowed.
my juniors are very insistent on this. Just make it clear your lordship has not gone into any other point of maintenance.
Like, I've always,
Just that.
I've always,
Just that.
लिखे दिन.
Not going to merits of the matter.
The suit is otherwise barred by the suit.
Needless to mention that this court has not.
This
And I also not had expected an objection to Order 7, Rule 10, to plaint being returned and that being objected to.
The application, that's all.
of course, that's the
Nice. Next.
For that, respondent number 6, my lord.
Petitioner.
Yes, I am for the CSC authority, my lord.
My lord, on behalf of the respondent number 6, the
Can you take
state
the
complaints are
previous order?
challenged, yes.
The CSC was directed to file a report. The facts are so, my lord, within the, my lord, litigation between the landlord and the tenant, landlord as usual locked up the room. The meter could not be approachable. There was a provisional.
CSC?
CSC, my lord. I am for CSC. This is a report of the CSC, my lord. CSC report.
What was your grievance?
Since there was previously there was an understanding that the provisional bills were being raised, that certain amount was due, and why we said, "Okay, you speak up what are my dues, I'm going to pay it out, or allow me to apply afresh." That was my
Who is appearing for the private respondent?
we have served, and nobody is appearing.
Can you see whether the service is complete?
Yes,
or
yes,
not?
service is there.
Service is complete or not? Because there is a private respondent and there is a case pending between the eviction suit since 2012.
What? There is no endorsement.
At the back, and the postal is there.
Postal track, what does
The
it
last
show?
one.
Unclaimed.
Hmm.
Door locked and then unclaimed. Unclaimed is good service.
Yes. But I was beseeching your lordship,
What is the problem? You are not being able to read the meter.
Yes,
yes.
Can you see my paragraph 3 and 4, my report? And I have also annexed the picture.
Yes.
Paragraph 3 and 4, and I also picture. Entire house is locked, my lord. And the meter is inside the house, my lord.
House itself is locked.
Yes, my lord. I give
No,
the
entire
picture.
house, they are residing. The tenants are residing over there. The portion where the meters are being situated, but that portion is entirely locked. And the most interesting aspect
my
is that
report in
Meter board position is not at a separate
no,
place.
my lord. And since 2012.
Very well. একটা লিখে নিন তো। Affidavit কার বাসা হতো সঙ্গে একটার নাম লিখে দিয়েছে না ও দিয়ে যাবে সলিসিটর ফর্ম দিয়ে নেক্সট
My lord, this is my petition. On the previous occasion, my lord allowed me the opportunity to serve and come back on the respondent for on the private respondent. My lord, I candidly admit I could not serve because my clerk was unwell. Kindly accommodate 1 week, my lord. I will serve and
Mr. Kundu, learned advocate, appearing for the petition. Yes, Mr. Mukhopadhyay.
My lord,
Connection will be
given. Connection will be given. Only one thing, my difficulty we are having, my lord, presently, the submersible pump. The entire area, my lord, is waterlogged. So some longer period of time be required, my lord, for installation. My lord, kindly give my lord 8 weeks time, my lord.
8 weeks?
Yes.
Well, 8 weeks is
Or,
too
my lord,
much.
Immediately after, my lord, the water being receded. Immediately, my lord, that I have taken.
I will say 4 weeks.
Yes.
Of the, or the, if
Rainy season is continued, very difficult. We cannot work there.
or upon the water logging being lessened, whichever is earlier.
Yes.
Take it 8 weeks, my lord. I have given instruction. It's up to 2013 payment has been made. Immediately, my lord, that will be done.
8 weeks will be too much.
Yes.
Well, make it 6 weeks, my lord. Well, my lord, they are saying, my lord, that
My lord, 4 weeks, my lord.
I'm not bargaining.
5 weeks.
Yes, yes.
This
and only one thing, my lord.
সকালে এসে মেনশন করলো না 23 somebody paid for time in the morning
24 মানে
But I beg to appear on behalf of the petitioners, my lord. Petitioner is the my lord, they want to obtain an electricity connection upon his premises, my lord. He has purchased it through a my lord, registered deed of sale. But I made a representation to the authority concerned, my lord. My lord, it find at page 62 of my writ petition I have annexed. And I have deposited all the requisite formalities, my lord. They didn't, my lord.
We faced vehement objection when there was an order also passed by the in a title suit, my lord, of 658 of 2025, where we were directed to go and give the supply. My lord, there we have attempted around 3-4 times, we could not. And lastly, my lord, we have given this letter, my lord, stating for refund. My lord, they have not taken the refund, but my lord, we have tried a lot. Right, we were obstructed every time by the private respondent.
You have served the private respondents
Yes, my lord, I have served.
affidavit of service is not
Yes,
there
ma'am. Affidavit of service, ma'am.
দেখি দিদি দিন
My lord, there is one also.
Basically a
Appearing for the
service
private-
connection.
You are appearing for the private respondent
No, I'm for the state respondent.
State will not have anything.
There is a dispute regarding the occupation and position
It
of
will
the
not do anything. They are entitled to connection if they are settled position.
We have tried on.
Yes, how have you served the private respondents?
My lord, in page number 48, there is a my lord, direction to the police authority, my lord, to give a permission to my lord, install electricity connection.
48.
Yes, my lord. There is an interim order, my lord, passed by the learned district judge.
It was in your favor.
Yes, yes.
No, we tried.
spite
My
of
lord,
that,
this,
my
my
lord,
lord,
they
this
didn't
was on
go.
15th of January, my lord. Subsequently, we tried on
You
5th.
take police assistance
My
and
lord, we have taken police assistance, but we could not, my lord.
how can that be?
My lord, we could not. My lord, that is my
My lord,
specific.
is still my lord existing.
Well, that is
Police assistance now and go and supply.
Yes.
Can. None appears for the
Morning, Madam. Granted the liberty to exchange the certified copy from the record in exchange of a photocopy, my lord. I have been instructed by your court officers, my lord, that it requires for a server copy to be signed. I have to
Yes.
file the appeal, my lord, tomorrow if my lord kindly allows me to.
Wait, you have waited for 3 months, wait for today.
My lord, kindly take it tomorrow.
I would.
ম্যাডাম সেকেন্ড হাফে এটা চলবে তো
কোডিং হবে
কম্পিটিশনও করে
ওটিতে সেশনে ওটি কথা আছে
This is my application under section 481 of the Companies Act for dissolution of the company in liquidation. If you also kindly see my application, all proceedings has been completed. Only thing, my lord, the only 7 lakhs rupees is remaining with the hands of the official liquidator. And my lord, though we have paid for, my lord, the accounts audited, but my lord, if your losses kindly see your losses predecessor's order.
Check করো।
But the official liquidator is also present before your lordships. But if your lordships kindly see the prayers made by me made in this application, prayer A, prayer B, my lord, prayer C, prayer D. But the funds, my lord, page 3, paragraph 7. I have stated, my lord, the funds 7,67,000. But these funds may not be, my lord, the sufficient for the purpose of, my lord, auditing, audit accounting, and, my lord, the publication, paper publication, etc.
What are the funds available?
My lord, kindly see page 3, paragraph 7. That is 7,67,265. And my lord, section 555, my lord, as of the Companies Act, my lord, if there is anything remaining in the hands of the official liquidator, my lord, that will be, my lord, deposited with the Reserve Bank of India.
And when were the assets sold?
My lord, the assets were sold, my lord. Kindly see paragraph. Yes. Paragraph 6, my lord. 3,85,000, my lord.
No, when, time, date, year.
Date has not been mentioned, but the date has not been mentioned. Sorry.
Intimate the date at least, which year it was sold.
Your lordships kindly then adjourn this matter. I will.
When do you want to come?
Tomorrow. I will.
Tomorrow I will not take up company matters.
The next available days.
Very well.
Kindly.
Likhen it as prayed for by Mr. Chaudhary.
I have sought for your dispensation of my lord filing of accounts. I have sought for dispensation of my lord causing advertisement. And my lord, I have sought for my lord an order of dissolution. You know, the reason why I have asked for my lord dispensation with final accounts and my lord for causing advertisement is because of my lord the meager fund position of the company. If your lordship my lord takes page my lord 7 of my affidavit in support of my lord the letters
is 7.
Page 7, my lord. Right on top, the unfinished paragraph, my lord, part of paragraph 17, remaining liquidation proceedings. Hence, as on date, there is a fund of around 1,46,478 after yielding applicable interest. My lord, to my lord carry out the accounts, my lord, that to my lord, one other thing which is perhaps not mentioned here, my lord, the books of accounts, since my lord, this is a very old company. The sales and everything, my lord, was conducted sometime, my lord, in 89, 2001, and my lord, there were the matter, my lord, went up to
Where do I get that? 89 or 2001?
I beg your pardon, my lord.
Where do I get when was the sale concluded?
Lord, I tell you, Lordship, Lord. Lord, kindly takes page 3, my lord, of my affidavit. Lord, paragraph 3, paragraph 4. Rather, my lord, paragraph 3 onwards.
If Supreme Court set aside the sale,
yes, ma'am.
Thereafter, what happened?
Lord, thereafter,
3 and 4 is prior to the Supreme Court setting aside. Thereafter,
yes, Lord, thereafter, your lordship takes Lord, paragraph 12, paragraph 9 and paragraph 12, if I may place it with your lordship, that by the orders of the Honorable High Court Calcutta dated 1997 March, officially was paid 6943 secured creditors, another secured creditor on the basis of ad hoc. Thereafter, in terms of Honorable High Court's order, 4th July, 2 secured creditors quashed their claims since they were not willing. And thereafter takes paragraph 11. By an order of the Honorable Supreme Court dated 6th February, the entire movable assets of the company at Asansol, Bardhaman was sold to Messrs. Wellworth Vanijay at a price of rupees 4.25 crores.
and when were funds disbursed to Bank of Baroda, which appears to be the only secured creditor? Page 16, you have said this was the fund available for final disbursement. But when was this disbursement made in favor of Bank of Baroda or at all where it was made? Nothing is mentioned there. Then suddenly you have said that 70,000 was kept and
My lord, that perhaps, my lord, your lordship will get some inkling, my lord, at page 6.
Page 6, I am reading at page 6, paragraph 16. Paragraph 16.
Paragraph 16.
Yes. At the time of final disbursement, a sum of such and such was available.
My lord.
What was disbursed then? If this was available, what was disbursed to the secured creditor? What was disbursed to the employees? Was this secured creditor at all paid or not? It's not clear.
It's not clear here, but my lord, prior, your lordship will, my lord, so far as ANZ and Standard Chartered are concerned, my lord.
No, ANZ Standard Chartered, you have said you have paid.
Yes, they, my
But
lord,
so far as Bank
relinquished
of
their
Baroda
rights.
is concerned, you have not said that.
No, no, my lord. No, it does not seem, my lord.
Take instructions on that. Inform.
Yes, my lord.
What has happened? Because I must be satisfied that all
Yes,
secured
my lord.
creditors are paid.
Yes, my
I
lord.
bow down.
Likhen as prayed for by Mr. Dasadhikari. List this matter after a week. 1 week will be sufficient?
1
or-
week.
Next.
Lord, this is again, my lord, a similar application, my lord, seeking for, my lord, dissolution. My lord, again, my lord, I have prayed, my lord, for dispensation of, my lord, publication and, my lord,
All the applications are for that only.
the ones which are with me, my lord, they're for dissolution.
The first 3 is dissolution.
First 3, my lord, are for dissolution, I'm told. My lord, here, your lordship will see at page 3, the liquidation was in 1992. assets were sold, my lord, sometime on 22nd, my lord.
You please, Mr. Dasudikari, in all these matters, please assist the court with a chart showing how disbursement was made to the creditors, because
My
here there is a blank statement in paragraph 5.
My lord.
Accordingly, disbursement of creditors of the company in terms of such and such. This is
And it stops.
incomplete.
It's an incomplete sentence.
We don't know
My
whether it was made, it was not made.
My lord,
So,
I will come.
since I am passing a final order of dissolution, I need to be satisfied with the records.
I will come back.
Please come with an affidavit in all those matters disclosing how it has been done.
My lord, then requires, my lord, an affidavit, my lord, of sorts, my lord, put
Yes.
together with how the disbursement happened.
Yes.
Very well.
Oh, সবকটাতে record করে নিন. The official liquidator shall file an affidavit disclosing the dates সবকটাতে থাকবে, যেগুলোতে অর্ডার হয়েছে মানে 13, 14, 15 যেগুলোতে সব 1 week হয়েছে, ওই রণজিৎ চৌধুরী সাহেবের argument তাই থাকবে। Yours also, there will be an affidavit.
Yes, yes.
Yes, next.
Lord, here I am for the respondent official liquidator.
Who is for the petitioner?
Lord, the petitioner is intending offerers who intends to, my lord, they purchase the property which is belongs to the state government. Now, my lord, if your lordships kindly see the order, my lord, if your lordships kindly see this order, my lord, the passed by the Honorable Justice Ravi Kishan Kapoor, my lord.
What was the 1st November 19 order, which was recalled?
My lord,
This order and order of 1st of November 19.
yes, my lord, another purchaser made an application for purchase of the property which is belongs to the government.
Which was allowed.
Yes, my lord, the government.
Been recalled.
Yes, that has been recalled. My lord, if your lordship, my lord, directs me, official liquidator can intimate to the state governments, my lord, the advocates to appear before your lordship, because it has been recorded in the order this properties belongs to the government. My lord, we have though intimated, but they have not yet, my lord, taken over the property from the official liquidator, and we are, my lord, paying the security guards unnecessarily.
Inform the state.
I'm deeply.
After 1 week.
My lord, may I take back this order?
Please, please take that. Next.
Peculiar circumstances, a restoration of a restoration. And interestingly, my lord, what we could gather from the records of your lordships, my lord, there has been already an order of 18th of January 2019, my lord, restoring everything, my lord. But that we could not find in the server, but it is with the records of your lordship's brief, my lord. So if that is so, my lord, then all these application has perhaps become redundant and everything has been restored.
এর আগের অর্ডার গুলো আছে কি একবার দেখেন?
আপনার কোনো ব্যাপার নেই।
You want restoration of which application?
My lord, both the applications ideally, my lord.
There is an order dated 18 January 2019.
Yes, my lord.
Restoring the CP.
Restoring the CP.
406.
CA 406 and CP 124. The
And
CP
this is for restoration of what? 406 only.
yes.
Then 406 was dismissed for default again after 18 January 2019.
No, it was not.
You are seeking recall of the same order dated December 14, 2018.
December 14, 2019. No. পুরনো।
এর signed copy কোথায় আছে?
পুরনো। কি হলো? Dismiss for default হলো। তারপরে restoration file।
On record, which appears to be a server copy. It is unsigned. Now, if you say it's not on server, then I need to be satisfied that there is an order. Let me call for the original order with the signature of the honorable judge.
That we need to
That will clear the air.
absolutely.
কালকে আনতে পারবেন না?
May I have a look at the order if your lordship, because I do not have it with me, my lord.
CP restored.
Precisely, my lord. Precisely, my lord.
Because
Both has been restored, my
Hearing
lord.
of CP will go.
Now, my lord,
this apparently appears to be a copy of the server. I mean, a printout of the
Yes,
server.
must be.
Or the server orders.
now, my lord,
It
the honorable
must be-
judge, my lord,
Yeah.
we really can't do anything about it, my lord. But that's where it
In
stands,
December
my lord.
2018, it was dismissed, and then 18 January 2019, it is restored.
Precisely, my lord. When the second dismissal happened, my lord, we filed another application, but that during the pendency of that application, my lord, somebody perhaps had filed another CP, my lord, that CA, my lord, that got this order was restored on the basis of that CA, which on our application. I'm sorry, my lord. Erstwhile advocate on record. This is a changed brief.
This is CA 406 only, or this is a different CA?
This is a different CA. No, this CA 406.
And what is CA 409 479 for?
That was another application for the for restoration of 406. It's slightly complicated. May I, my lord? A CP, my lord, was filed, my lord.
406 was dismissed for default in 2015.
2014, my lord.
2015. Page 6 of CA 479.
Yes.
2015.
Original CP.
So this is for restoration of that.
Yes.
Yes.
But 406 of 2015, how this stood recalled by 18 January 2019 order, but this CA was not disposed of then.
That is the reason, my lord, we are facing some difficulty, my lord. But when we are putting, my lord, the cost title and the numbers, my lord.
CA 479 of 2015 এটা ফাইল রয়েছে এই 7 একই সিপি তে আছে তো দুটো এবার 479 of 2015 ফাইল হয়েছিল এই CA 406 of 2015 টাকে রেস্টোর করার জন্য এই অর্ডারে 406 of 2015 রেস্টোরড হলো CA 13 of 2019 তাহলে এইটা কি হলো
Grateful, my lord. Grateful. There's not once. There's not once I got a simple matter before your lordship. Not for once. Grateful. my lord.
RAM for the official liquidator.
What is this application for?
So this application has been filed by one of the legal heirs of the landowners seeking certain direction.
Substitution, basically. Application for substitution. No use dismissing this. Let them come. Just making it not this week.
Very good.
This will cause hardship.
No.
Next. None appears for the petitioner. কোনো dismiss for default হচ্ছে না তাহলে
At 20 and 21, I will appear for the petition. This is the application taken out by ex-workers. They were the workers of the company in liquidation. They had superannuated before the company wound up. They had obtained the retirement benefits and then reinvested the same in the company for better returns. Thereafter, the claim was admitted by the official liquidator, but the claim has not been disbursed. I will kindly see page 16 of the application. That is the order of the division bench. Similar application as was item number 20. 9 June 2025, my learned friend appeared in that matter, my lord. There they had supported the claim, and they page 18 is the observation of them. The proportionate pro rata distribution should come to every ordinary claimant whose claim has been admitted, and they release that amount. That amount was directed to be released in favor of the applicants. A similar prayer has been made by the applicant. Their claim was also admitted by the official liquidator. Now I am seeking whatever pro rata distribution claim is coming to in my part, that may be given to me by the official liquidator.
So your claim was also included within this admitted claims which forms.
Yes,
provision
yes,
of the order.
yes, yes.
So why should payment not be made to them also if they have, their claims have been admitted?
Filed disbursement application. Well,
Did you file any claim?
Claim admitted. Similar prayer.
Lordship, we do not have any problem in disbursing the amount, but considering the pleading of the applications, if Lordship directs, we would like to file a report.
File a report. Let them file a report. It will make things clear. लिखे नहीं.
Both
For
the
both-
matters, my lord, both
For
the
both
matters.
the applications, may we file a single report?
Yes, yes. তাহলে ওই দুটো একসঙ্গে করে
Lord, I am for the official liquidity.
My lord, I am the petitioner in this application. My lord, I am for a home buyer, and my lord, I am seeking for
buyer.
Yes, my lord. My lord, my contention is that I have paid the consideration, and I am seeking orders for execution of conveyance. Not on the last occasion, not the earlier coordinate bench has directed us to serve the application on the RP because the service was incomplete. Not now the service is complete. If my lord, this is the affidavit of service.
Have we switched? Very well. You serve another notice because it has suddenly appeared. They might not have got the notice of it. Just a notice, not the application. I'll fix it after a week.
Very well, my lord.
Affidavit of service filed in court today is taken on record. Full stop.
My lord, I am appearing for the petitioner in this matter. My lord, this is a PLA application. And lastly, I have filed this application for condoning the delay of 57 days to filing published in newspaper, my lord. The publication of newspapers order has been passed on March 26, 2025, and I have published it in 21st May 2025 in English newspaper and in Bengali newspaper on 23rd June. That's why there is a 57 days of delay, my lord. That should be condoned, my lord.
Why did you incur the delay?
My lord, there is a financial hardship and there, that's why.
Okay. This is an application seeking
and the inventory. 187 days of delay. It's a joint prayer. I've made a prayer for both granting of leave to file my inventory and accounts. The probate was drawn up and the grant was drawn up on 26th of June 2025. 6 months time was given for me to file the inventory and 1 year period for accounts. This application was filed on the 30th of June. So I've calculated the day where elapsed from the day of filing my inventory. That is 187 days. I've prayed for condemnation of that and thereafter the accounts. Your Lordship. Reason for delay, the administrator was very sick. I've annexed the administrator was extremely sick. All three of them are senior citizens and some gallbladder stone issues was there.
My lord, I appear on behalf of the petitioner. My lord, this application has been filed under section 283(3). My lord, one of the properties in the affidavit of assets lies in Pondicherry. So to issue a special citation upon the decision, but now in view of the division bench's order, this application is no longer required. So my lord can pass orders in terms of the probate. Sorry, my lord. Yes, my lord, citation has to be issued. My lord, regarding all those matters where the property is lying outside, the court has the powers to grant probate. So, my lord, may pass as necessary orders, my lord. My My lord, I don't have the printout. If my lord gives me a passover, I'll get it. I shall.
Lord, this is my amendment application, my lord. Hard yesterday, my lord. Your lordship passed an order. By mistake. May it go out of the gate.
May it please, Your Lordship. Lord, this is my affidavit in support of the master summons that I've taken out at the instance of the executors of the will dated 23rd December 2019. My Lord, subsequently the testator died and the will was probated on 26th July 2024. My Lord, this will was, although the will was probated on 26th July 2024, it only received the seal of the this honorable court on 20th March 2025. My Lords, in terms of the dictum of the probate, I had to administer the estate of the deceased and to file a true and full and true accounts of the properties that were to be administered within 6 months, and thereafter within 12 months to give the accounts thereof, my lord. Now, 6 months and 12 months both have expired. These have expired on 10th March 2025. I'm sorry, 19th September 2025, the 6 months period expired, and 19th March 2026, the 12 months period expired. Now, my lord, why the estate of the deceased could not be administered is because your lordship will kindly appreciate there's a property, a brick-built building at Sector 3 in Salt Lake. Now, the deceased had leasehold interest over the property. Since he had leasehold interest over the property, any assignment that could have been made of the leasehold interest could be made by way of a deed of assignment, my lords. Now that the executors have been able to catch hold of someone who's interested in getting the balance period of the leasehold interest. Now the only difficulty is that a prior approval is to be required from the statutory authority. That is still pending, my lord. And also in light of various decisions of the coordinate bench of this honorable court pertaining to properties in the area wherein whether transfer fees will be applicable or not, insofar as transfer of the leasehold interest over the property is concerned. So there are notifications also that have come in. We are in the process of doing this. The executors also 76 and 85 years of age. They are moving along diligently, my lords. I was only beseeching for another 6 months' time, my lord, for us to give this, to put this to a quietus, my lord.
Lordship, I am for the state lordship. As per the last order, 15 June 2026, my lord, there is a direction upon the service upon the, my lord, advocate on record of the state lordship. And therefore, in pursuance of this order, I am appearing, lordship.
Yes.
Lordship, only we having the copy of the application. If the application,
May I,
what
my lords,
happened?
may I just indicate, on the last occasion when this matter was taken up, the honorable judge who was adjudicating this instant application was of the view that he wanted to understand the current status of the property insofar as the leasehold interest is concerned. Now, my lords, I am conscious of the fact that any assignment of my leasehold interest cannot take place without the prior consent of the statutory authority. Because of which I am here before your lordships, taking time to follow the dictum of law and to put this entire thing
Because
to a
if I
quietus.
extend time, I will extend time to do whatever you have to do in accordance with law only.
Yes.
Yes, you have to say something.
My lord, lordship, the state role is very limited. Whether they have, they can transfer the property with the after the consent taken by, from the state authority UMDA or not. Only that part I have to look after, my lord. Not beyond that.
Because I'll tell
That I
you,
will
the
observe.
title. May I just indicate, my lord, this will has already stood probated by this honorable court. Once it is probated, perhaps the dictum of the will cannot be looked into so long as it is in
কিসের জন্য আছে? Not today করে দাও। Next. Out of list করে দিন, কেউ থাকছে না ফালতু ফালতু রেখে লাভ কি? Out of list. Next.
My lord, this is an application, my lord, for amendment of affidavit of assets, my lord, which my lord is no more required to, my lord, proceed with, my lord. I am withdrawing that application, and my lord, I am praying for, my lord.
You are the advocate on record.
I'm the advocate.
লিখে নিন। Learned advocate appearing for the petitioner.
My lord, I am for the petitioner.
I'm opposing this bill.
My lord, this is the affidavit of service.
I'm opposing this application, my lord. I am for the respondent, my lord, in this matter.
My
I am for the caveator, my lord.
Caveator.
Yeah,
You want discharge of caveat?
yeah, I applied for the discharge of the caveat because in the
Your
caveat,
opposition to this.
My lord.
yeah,
My lord, my humble submission, a caveat is simply a warning, my lord, that whether.
Well, since he has made an application seeking discharge, respond
My
to
lord.
this, whatever it is.
My lord.
my lord, in the caveat and in the GA before that, they said nothing against the will. They
Not
accepted the
required.
will. Yeah,
Not required.
I'm saying that, my lord. The caveator said that she was never informed of the petition for probate, but it is untruth. This is not true.
Even if she was informed.
She was informed.
Even if she was informed.
Yes.
She has the right to lodge a caveat and oppose the
No,
grant.
she has the right, but
On that ground, you cannot seek discharge of caveat. Discharge of caveat.
what
on what
what
ground?
I
That
am
is not a ground seeking discharge.
what I am trying to say, my lord, is that what the caveator said in the GA and in the affidavit
Let
for
her file her affidavit in opposition. लिखे दे.
My lord.
This is an application seeking this.
Lordship, this is my application, Lordship. Lordship kindly recalls it came up for hearing yesterday, Lordship, wherein Lordship had raised one query regarding the format of the application.
Yes.
That general for issuance of general citation.
আরে এটা অঞ্জন দা এটা কথা বলার ছিল তো যে আমরা amendment allow করে দেব কিনা দেখি একবার making it not today come tomorrow I didn't see it হ্যাঁ
Lordship may allow it, Lordship, as a separate.
no then you may have to amend it. Let me see the original ইয়েটা দেখার দরকার ছিল আমাদের petition for grant of probate আছে এই প্রেয়ারটা নেই তো না প্রেয়ার স্পেশাল সাইটেশন জেনারেল সাইটেশনের প্রেয়ার গুলো কোথায় থাকে এখানে The application for amendment হিসেবে treat করে এটা হ্যাঁ an application for amendment
I'm correct.
but তাহলে ইয়ে নেই কিন্তু reading নেই ডিপার্টমেন্টকে যে ডিরেকশন দেওয়া হয় টু ক্যারি আউট দি অ্যামেন্ডমেন্ট তাহলে একে লিভ দিয়ে দিই এখান থেকে দেখুন না ঠিক আছে
Page 3 of my GA1.
Just a minute, madam.
Lordship.
Yes.
Lordship, paragraph 4, I have stated that the deceased at the time of his death left behind his wife, Chobi Shaha, who is now the sole executor. And the petitioners.
You have taken a change from the caveator.
Lordship,
Because the caveat was.
no. Lordship, the caveator, yesterday also I indicated, they are the two sons. We have already filed the affidavit on their behalf. The affidavit of consent, Your Lordship, I was only reading paragraph 4. That is where it is stated. And the petitioner herein and his two sons, Rajiv Shah and Partho Shah. Now, this is a will of 2021. And in 2022, Partho Shah had filed a caveat. Now, today we are in 2026 and this probate application was filed in the year 2025. While we were proceeding with the proceeding before the testamentary department, it came out that there exists one caveat, Your Lordship. So only on that respect of that caveat filed by Partho Shah, who has already filed the affidavit of consent in the PLA, we only want a discharge from that caveat because it has now become redundant.
Very well. लिखे नहीं.
Prayer.
Lordship, this is my application for amendment of the cost factor. Lordship, lock, stock, barrel in the application made before your Lordship for grant of probate, the address of the person in the goods of has gone down as something and it should have been made as something else. That we have obtained from the death certificate. It was by mistake, it was put down as something else. That is why this is my application. I have marked all the proposed amendments as Annexure X, which includes every single document filed before your Lordship. So only with respect to the cost center.
Amendment of लिखे नहीं. This is an application for amendment of the
Item 12 is a similar application like the last one, amendment for changing the address in the cost title of the deceased. I would require this amendment for all the cost papers, in the sense that the affidavit of witness, affidavit of assets, attesting witness, and the two vokalatnamas and my probate petition.
Yes, so all of it.
All of it.
All of it. So same orderই হবে শুধু annexure X যেখানে ছিল ওটা annexure A হয়ে যাবে
Annexure millets A, B, C, D, E. I have marked them separately.
annexure A B C D E করে দিই X এর জায়গায় A B C D E হয়ে যাবে বাকি সব সেম একই জিনিস ঠিক আছে GA1 disposed. Yes.
Can I mention this matter, please, my lords?
Let the appellate side be called on. অঞ্জন দা একটা ভালো কোম্পানিজ একটা চেম্বারে পাঠিয়ে দিতে প্লিজ ঠিক ঠিক দিদি কালকে বোধহয় অ্যাপেলের অরিজিনাল সাইডে একটা মামলা হচ্ছিল তাকে কোথায় গেলেন রঞ্জনদা হচ্ছে একজন কেউ মামলা করছিল হ্যাঁ উনি দিয়ে গেলেন কালকে ওই মিস মঞ্জু ম্যানর মামলা করছিলেন না একটা এই বইটা ওনার এখানে রয়ে গেছে হ্যাঁ দিয়ে দিচ্ছি কারণ এই ফালতু এখানে পড়ে থাকবে Yes, madam. Onar key mentioning.
This, my lord, this is a matter of civil. It's a civil revision filed in 2024. I've recently received the order of the lower court, this matter is in Justice Hiranmoy Bhattacharya's bench, but the lower court has suggested that if the matter is not stayed, then the matter shall be proceeded in the lower court.
See,
Kindly.
what is the problem? 2024 it is pending. How can it become urgent in 2026?
25. Yes. My apologies, Lordship. The civil revision has been filed in 2025.
What was the subject matter of challenge?
This application was under the application that was made was under Section 8 of West Bengal Land Reforms Act, and my client had filed an application under Section 21, under Section 21 and 21 and 18.
Grounds of urgency and give it. Write your grounds of urgency and give it. We shall see. Next call for this.
My lords, that is here.
It's my application. Pursuant to your lordship direction, this is my affidavit of service. Door locked, but this is a good service. I have some judgment for it.
একটা ফ্ল্যাগ লাগিয়ে দিলে সুবিধা হবে
This is a landlord tenant dispute. Landlord
করতে পারি Yes.
My lord, this is land. My lord, this is a judgment, my lord. Paragraph 19, my lord. Door locked is a good service. My lord, he is avoiding the service. My lord, this is a landlord tenant dispute, my lord. Suit is going on before the court below, my lord. I am the tenant, my lord. Landlord is obstructed me. My lord, for which my electricity has not been effectuate. My lord, without police help, it cannot be done, my lord. Access has been given.
Yes.
And page 38, lordship kindly see, no access has been given to the CSC authority for providing electricity or inspection. And this is the reason why I have come before your lordship.
You are a tenant or they are tenants?
I am a tenant. I have a shop, suit is going on.
No, but this is door locked item kept on hold. This is not conclusive.
My lord, kindly see the next page, last page, top. Judgment, last page, top. My lord, house closed is a good service.
The delivery has
My
been
lord,
kept on
Delivery is yet it is kept on hold. Please try to understand
Oh,
what you submit.
sorry, my lord, I'm
See page 15 of the affidavit of service.
kept on hold. Kept on hold.
Left hand side. Go to the left hand side of the chart.
Yes, kept item kept on hold.
Yes.
Kept
So it
on
is-
hold, door
it is
lock.
still with the postal authorities, they may go and serve it again. Please wait for some time. Click on.
Then, no, it kept on hold. Taken out for delivery.
May it please the Lordship. That I appear on behalf of CSC.
Lord.
Lord. Head of electricity. 2025. 2025. And my lord, provisional order and the final order has been passed. The amount is so big. That 1,46,000. 46,000.
1,46,000.
Yes, because of one. I will only show 2 pages, my lord. Final order is at page 20, which is of 5/5/2025. And the writ petition has been affirmed on 26/5/2026. In paragraph 13 at page 4, they have accepted that they know the final order.
Yes.
But after that, in terms of 127, this writ petition is not maintained.
My lord, my learned friend, if you would have come within the period, I would have granted you leave to approach the appellate authority, extended the time.
That I know also.
But now it is difficult.
Difficult. So, my lord,
More than 1 year has gone.
but now I am suffering. I have to get electricity. Without electricity.
I will do this. I will dispose this off. You make a prayer for installment, they will consider it in accordance with law. That is the most that I can do.
Or in the meantime, I'm paying 50%.
That I will say, they will consider it. I cannot make a mandatory order. That is not there now. Earlier we used to have those orders, but now we don't have it. You also know, everybody knows.
That is, so that pair
4 weeks from the date of.
I'm grateful. I am for the petitioner, my lords. We have served the private response. Very short question, very short question.
Next.
We are for the respondent.
No, I am for the petitioner. I am praying for a leave to file a supplementary affidavit. I'll take it up next week, my lord, your secret.
Mr. Samantul, learned advocate, appearing for the petitioner.
Which?
Speaks.
Lordship, I am for the petition. Affidavit of service. Lordship, petitioner is the tenant, Lordship, depositing rent before the rent controller. Lordship, applied for a domestic connection. Thereafter, CSC authority sanctioned the meter. All compliances have been done, but due to the objection, the installation has not been.
For the private respondent.
The last occasion.
Nobody appeared.
My instruction is that the private respondent have locked the meter room, my lord. We need police help, my lord, along with the direction to break open padlock for installation.
Last occasion, somebody had appeared.
Yes, there was a direction upon me to serve afresh. I have served both of them.
Can you contact over phone?
The name is not given.
Yes,
my lord.
yes, but Mr. Dinesh Chatterjee appeared on the last occasion. He was here.
Passing it over if you can bring it, because in his absence.
I will not pass it over today, my lord. My lord, today.
Not today. Kalke hobe.
Affidavit of service?
Returning.
How many issues?
We'll come back at 4 o'clock.
Up to you. You did not want a passover.
Yes.
Tomorrow.
Tomorrow.
সাড়ে তিনটে থেকে ফিক্স আছে দুটো হিয়ারিং
Lordship.
Next. Petitioner, लिखे नहीं.
Appealing for the WBSCDPL, my lord.
Same order, Dada. Same order. আচ্ছা ওই রেসপন্ডেন্ট WBSCDCL is represented লিখে দেবেন দুটোতেই। Next. Same order. In.
Lordship, I'm appearing on behalf of the ICICI Bank. We have still not been served. It's for the third time.
ওই লিখে দিন none appears for the petitioner. ওই সেম অর্ডার হবে যেটা আগে লিখলেন none appears বলে এই জুলাই 17 এ
That's a.
Appear on behalf of the petitioner.
Oh, welcome. I for the state, Lordship.
I appear on behalf of the petitioner, my lord. This is my application for refund of the excess money which I have given in line with the OTS proposal. I was the borrower with the bank. I had availed loan since the year 2006 to 7 to 8. Even admittedly, I had defaulted 13 to 13-4 against me. Thereafter, a decree was passed by the DRT, by the learned DRT of 11,20,000. RC case was filed. After the filing of the RC case, I approached the bank with the proposal of an OTS. I stated that in the year of 2024, I am willing to pay an amount of 56 lakhs and settle the amount. The bank did not agree. The bank said that you pay us 70 lakhs and then we will consider. However, I was approached by one of the DGM of the respondent bank who had intimated to me that my 56 lakhs OTS proposal is acceptable to them, and accordingly, I had written to them a letter and had also attached 2 checks which recorded the upfront amount of 11,20,000. That amount has never been refunded back to me. For that amount, I have already initiated separate case. It is going with the learned DRT.
The next date is on 30th
then
of
why have to
July.
come up here?
Yes,
If you are appearing before the DRT, get it done there.
And the next date
My
is on
lord,
30th
thereafter,
of July.
You avail of parallel remedies.
my lord, thereafter 2 years passed, nothing happened.
So that is not a ground for you to approach the High Court. What is the proceeding?
No, my lord, the matter has now settled. The matter has now settled. Thereafter, 2 years later, the bank officers changed. The new officers suddenly started chasing me, stated that you please pay us now or we will dispose you of your assets.
Kindly see page number 63 once, Your Lordship.
63.
Your Lordship will see the order. This order was passed on 11/6/2026.
Yes.
Lordship, at the next page, we'll find that the matter is adjourned till adjourned to 30th of July 2026. The date has not yet come, Your Lordship. We are in the process, Your Lordship. The order crystal clearly says that yes, we need to refund the money. In case there is a breach of the order, they can come up before the court of law, Your Lordship. Now the matter is pending there.
Well, this was regarding the amount of 11.20 lakhs, which I have.
You cannot have bifurcated causes of action.
Madam,
For
I'm
one
not.
part you will
I'm not
approach
asking
the
for that 11 lakhs today. In this second OTS proposal, they again asked me to pay upfront 86 lakhs and then they close the account. Under duress, I had to pay. My original, according to the first OTS, my amount was 56 lakhs.
Under duress or not, how will the writ court decide all this?
That is disputed by us.
Verbally, they have threatened us, my lord, that we will dispose it.
Decide it was verbal threat or not. Cannot be decided on affidavit evidence.
Our contention is, my lord, that once you have accepted the first OTS and you have not refunded the money, second OTS.
My lord, first OTS was not accepted. They did not pay the entire money. The amount was forfeited. Then, my lord.
What is the total due?
Now 86 lakhs they have paid, they have obtained the no due certificate and they have annexed it, Your Lordship. The no due certificate is there. The earlier OTS failed and thereby the tribunal has said they refund back the earlier amount, which tantamounts to 11.20 lakhs. And the next date is posted on 30th of September. We have to comply with that order.
Our contention is that the 56 lakhs which was due.
How much have you paid in total? Tell me that. There were two OTS proposals.
Yes.
Yes, my lord.
Under the first OTS proposal, how much were you required to pay?
I was required to pay an amount of 56 lakhs.
Let us go one by one. Total dues was?
Total dues was, my lord,
90 lakhs.
2 crores 72 lakhs 95,000.
2 crores.
I had availed the loan. The amount due was my lord.
My lord, that OTS was not. I'll show, my lord, the documents.
Let him complete.
My lord will kindly come to page 53. 53, my first OTS.
53?
Yes.
Yes. 53.
My lord, I am thanking them for accepting my OTS of 56 lakhs.
So this was accepted. 7/3/2024, it was accepted.
Yes, my lord, because
show me the letter of acceptance.
My lord, they have not issued any letter of acceptance. In that same letter,
be accepted, sir. It has to be by a letter of acceptance.
They have not issued any letter, my lord.
Then it was not accepted.
On the left hand side, if my lord sees, the handwritten there is written, if the proposal will be rejected, then we will return back the 20% initial amount.
So this was 20% upfront, which we are supposed to pay. Which
yes, I had paid, and this was not refunded back to me.
20% was not refunded. This 20% was how much?
This 20% was, my lord, 11 lakhs 20,000.
This was 11 lakh. Very well. Next proposal, when did it come?
Next proposal, my lord, will kindly come to page 55.
Page 55. Page 55, yes.
Submission of one-time settlement proposal of 86 lakhs.
This was accepted.
Yes.
This was accepted. Under this,
accepted and you paid.
Yes.
I paid.
So what you want a refund of 11 lakh that they will refund.
11 lakhs I have already initiated different separate proceedings.
Yes,
my contention is that my initial dues were 56 lakhs, out of which I have paid excess of 86 lakhs. Therefore,
there is no initial dues of 56 lakh. There was a proposal which was given to you along with an upfront payment of rupees 11 lakh. That, according to you, has been retained by the bank wrongly, which the bank is liable to refund. This is one. Apart from 11 lakh, you have not paid anything else.
Apart from the 11 lakhs, my lord, under the second OTS,
Second OTS has been accepted.
Yes.
Second,
so whatever you have paid, that second OTS has been consumed towards liquidation of the loan that you had availed of from the bank. So let us forget the second OTS, because second OTS is towards repayment of the loan. Loan is repaid by the second OTS.
My lord, but I am agreed by the second OTS only. I am agreed.
You don't want the second OTS to go through.
Second OTS, I am saying that, my lord, under the second OTS, I have paid extra amount of 30 lakhs, which
it can't be. If the OTS itself is of 86 lakh, you cannot unilaterally scale it down to 56 lakh because your first OTS said 56 lakh. Then you ought not to have agreed to 86 lakh. This letter is yours.
My lord, there are few judgments which I intended to side
that
with.
Is
my lord,
judgment. Come on, facts. Your first proposal was for 56 lakh. Out of that, you paid 20 lakh, 11 lakh. for the purpose of upfront satisfaction showing your bona fide. That was retained by the bank. Subsequently, you made another proposal. You enhanced it from 56 to 86. 86 was accepted. You paid off. Loan squared. Bank did not refund the 11 lakh which bank had retained in terms of your first proposal. That is what you are entitled to. Now you cannot ask the bank to refund the 86 lakh and go back on the proposal of 56 lakh. That was not accepted, not acted upon. If it was acted upon, you should not have accepted the second proposal or given the second proposal.
My lord will kindly give me one chance. I will come back tomorrow and cite judgments and try to impress upon my lord.
Come back. लिखे नहीं.
Madam, it actually. Wait for me.
At item number 36, I appear for the opposite party number 1. My lord will remember we preferred an application, CAN 1, for vacating the interim order that has been obtained by the petitioner.
Matter was being heard on merits.
Lordship,
That was heard on merit. Mr. Bachawat was arguing, my lord, on behalf of the opposite party number 1. Today was the date fixed for continuation of the argument.
Where is Mr. Bachawat?
My lord, Mr. Bachawat is stuck in 25. My lord, if may kindly give us a passover, Mr. Dasgupta will start and resume it. He's on his way.
Mr. Bachawat was yet to complete. He had not completed on.
Yes. Mr. Dasgupta will be carried out.
My lord, I appear for the respond number 2 in this matter, my lord.
Passed over. Next.
Great.
Passed over. Next. For the petitioner. Yes, did.
My lord, the interim order lastly extended, my lord, is going to expire on 31st of July, my lord. My lord, the subject matter of challenge in this writ petition is the rejection of my application for occupational charges. Myself being the degree holder, my application was rejected in Order 9, Rule 13 proceeding. Now, this is the second rejection. First rejection was challenged before this honorable court. That order was set aside, my lord, and the matter was remanded, my lord, by a detailed judgment and order observing that myself is entitled to the occupational charges.
I'm extending it. I'm not the regular.
My lord.
Hold on. Passed over. Next. No, 36 was there. 37 was called. Both were called.
Yes, it is somehow missed.
Next. Just now called. The earlier matter was of Mr. Bachawat. He was not there. Next was called.
Tomorrow and day after, my lord, I will not be here. My lord, in town. Then, my lord, kindly fix it on Monday.
For whom? Petitioner.
I'm for the opposite party caveator. Plenty.
Wait, I'll be taking it up after.
Oh, very
It
well.
was just
Then,
one-
Lordship,
in
39, my lord, the interim order is expiring
Come back. Yes.
My lord, my apologies for appearing virtually today, my lord. My lord, in item number 38, interim order is expiring on end of July 2026, my lord. Therefore, I'm praying for an extension. This is a matter of a lordship ordinate bench, my lord.
What is this item number 39?
39.
Lordship, I am appearing for the respondents. Lordship, the interim order was extended twice before. And the matter was also fixed. Your Lordship was not there. Your Lordship was sitting somewhere. So if this matter, I am not standing in the way of the interim order being extended.
Before
Lordship,
the
but let it
regular
be
bench.
specially fixed.
Regular bench.
Hmm.
Take it.
I'm grateful.
Having heard the learned advocates appearing for the respective parties, the interim order passed earlier is extended till the end of August 2026 or until further orders, whichever is earlier. List this matter in the combined monthly list of August 2026.
So grateful to you, Lordship.
Next.
Particular, I am for the petitioner, my lord. The order was passed, your lordship, my lord, is my lord 31st up to 31st of July. My lord,
Same order, same order.
it will appear in the month of August, my lord. It will appear.
Monthly list of August and end of August.
My lord. Up to end of August. Good.
Next.
Madam, it will be. Grateful, my lord.
41, I am for the petitioner.
For the
Order is
respondent.
going to expire on 31st of June.
For the opposite.
Same order.
Grateful, Miller.
Having heard the learned advocates,
May I give my appeal?
please give your appeal.
Didi.
Next. Thank you.
August 10 to I am for the petitioner, 42.
None appears for the opposite party.
There is non-appearance.
Lord, I am for the petitioner. Lord, pursuant to my lord's earlier order dated 13th May 2023, but I have again served notice. Service has been effected. This is my appeal.
Affidavit of service filed in court today is taken on record.
Number 44, I am for the petitioner. My lord, interim order is going to expire on 31st of June.
Same order.
Grateful, Miller.
Lordship, I'm praying for the fixation of the date for the hearing since it's pending for a really long
Not
time.
the regular bench.
It will appear in the monthly list of August.
Monthly list of August, it will appear.
Grateful, Miller. Deeply. Honored.
Next.
I am for the petitioner, my lord. Interim order is till 31st, my lord. Size I have served.
Affidavit of service filed in court today is taken on record. None appears.
My lord. But what can be at 2197 there? The court.
If you filed by this time, it would have been done.
I have filed both, my lord. The court is not taking up the matters. Said that it has reached to the High Court, so I will not take up. And my own case has been stuck.
Yes, so you can mention it and get it done then instead
My
of
lord.
getting it. If you have filed order 21 rule 97, then we can dispose it of directing the court to take order 21 rule 97 application instead of 208 CRO.
2197, I did not file. I filed 208. Court said 208 is not maintainable. You have to.
There are judgments
Yes.
against
By our court, High Court, my lord.
but there is a Supreme Court now.
Yes. On 208.
Supreme Court is on 2197.
But I checked lastly, my lord, 208.
Justice Pardiwala's judgment you check.
Thereafter also, my lord, on 2197, there is an overlapping judgment on 208, my lord, CRO.
Supreme Court.
My lord.
Show me tomorrow, give me a copy.
I will, my lord. I will.
Password call করে দিন দিদি।
Grateful, sir.
ওনারটা call করে দিন না। I will take it tomorrow. There is another one which
I am for the WBSC edition 27.
No, Mr. Rai is accusing me of not calling his matters. ওটা call করো। I know you will not accuse, so I have kept it tomorrow. If Mr. Bachawat isn't here.
We had a proposal which fell from your lordship on the last day also. Here there is the petitioner is a third party to the arbitration proceedings. The petitioner says, although the prayers are different, the petitioner of the last occasion said that they just want to be in the reference.
If both of you agree, come and mention tomorrow. I'll finish it off. Saying that.
Very well. We are agreeable that the AMR, the petitioner can be there, but without any right of audience, they can watch whatever is going on. And they will
have right of audience. They will not be able to take a contradictory stand.
Contrary stance, yes. Contrary stand to the JV. You are for Odisha. This is respondent number
My lord, I
2.
appear for the respondent number 2 in this matter, my lord. This
happened since the arguing parties are not, I mean, counsel.
I can start. Mr. Bachawat is coming, but the petitioner is not here.
Let us do it clean.
The petitioner is not.
637 টা call করুন হবে না।
May I make one request? My colleague is coming from Delhi. Will be a lordship's pleasure to keep the matter tomorrow, or the matter may be taken up tomorrow sometime, or some
time tomorrow when it can be taken up.
But anytime subject to your lordship's convenience.
কালকে তো আবার ডিভিশন বেঞ্চ থাকবে। এটা তো অ্যাসাইন ম্যাটার। পরশুদিন রেখে দিই। Friday.
Very well. Friday ঠিক আছে। Friday ঠিক আছে। Oh, the petitioner is here.
Friday.
Friday. Finally, I have to take in senior instruction. Mr. Joy.
You are not arguing. Mr. Bachawat is arguing.
Then your lordship takes up any other day.
Tell me a date so that I can fix it. I'll fix a time then, because
anytime next week, subject to the petitioner, Mr. Kaur is appearing. I believe for the petitioner.
Tell me then.
Kindly also keep me.
Come and tell me at 4:30.
Lordship may keep it any day. Subject to your lordship.
Then again, it will be the same thing as it is today. I had kept it today. Nobody was there.
Yes.
So you tell me a time, tell me the date so that I can keep it at that time.
Lordship, keep the matter any day and during
day, but you are not agreeable to Friday. So
during this period of time, kindly Lordship, extend the interim order.
That I will extend.
Yes.
When it reaches 31st July. But
can it be anytime tomorrow, second half, after?
Tomorrow, second half, I'll be having division bench. Then I'll be having original side.
Then Friday, anytime?
Yes.
Keep the matter on 4:30, Lordship. I have to take instruction.
We'll come.
Because then we'll be able to fix the date.
Very well, my lord. I'll come.
Yes. Chalo, next.
Grateful, my lord.
But I am for the plaintiff opposite party, my lord, in the revisional application.
Your lordship, first thing I want to draw
I have a preliminary issue with regard to the maintainability of the instant revisional application, my lord. If your lordship looks at, my lord, the tenor of the order impugned before your lordship, it's the second round of litigation. Initially, my lord, the allegation on the part of the defendant is that there was a caveat lodged, and in spite of noting of that caveat, my lord, the copy was not being served and an interim order was obtained. My lord, they filed an application for vacating of that order. I'm coming, my lord. I'm coming. My lord, in whatsoever the ground my lord, if someone is asking for variation, vacating or modification or recalling of an order of injunction, it has to come because 151 cannot, my lord, lie. It's only order 39 rule 4 in the aid of which, my lord, this can be done.
There is a slight distinction, Mr. Mr. Mukherjee. Recalling of an application on the ground of not being heard or on the ground of violation of natural justice will not strictly fall under Order 39 Rule 4.
The same argument was advanced on the earlier occasion.
There are judgments and it is settled that there is a difference between a review and a recall. Review is statutory, where you have to have a provision, a pigeonhole within which you have to fall. If there is no provision for review, I cannot inherently exercise a power of review unless I am a constitutional court. As a constitutional court, I have my inherent powers to review. If I am a court other than a constitutional court, there has to be a provision for review, otherwise I cannot. But recall, for example, if an order is obtained by fraud, if an order is obtained in violation of principles of natural justice, then in that case, I have inherent powers to correct that. So it is the inherent power to correct its order on the basis of which it can recall. So this recalling will be within that bracket. Get my point? So here it may not fall strictly within the parameters of Order 39 Rule 4. Subject to what you say, prima facie.
I shall show before your lordship the application of there. Not why, my lord, I am rather inviting your lordship to decide on this point. Lord, today they have asked for, my lord, vacating of the order. Explicitly, my lord, vacating of the order.
Before my learned friend starts, can you the last page of this revision application? There is noting, caveat noting. Caveat noting is there. If you logically consider in instance, what is the procedure adopted by this High Court for lodging a caveat?
So that's Mr.
Yes. Not merit. It has some bearing. Otherwise, I'll not invite you.
That's bearing on the merit because my Mr.
What is the procedure adopted by this honorable court for effecting a caveat? Whether there is any separate procedure is there for the lower court, save and accept civil rules and order. So that things my lord has to satisfy your lordship whether what procedure we adopted.
That's not on merit because that's not the subsequent amendment of the Code of Civil Procedure. Yes, that's what.
Yes.
But now, my lord, if there is a specific provision, according to me, my lord, again, subject to correction by my lord, if there is a specific window given under the statute, then my lord, section 151 will not be adhered to. My lord, that's the law. Now, my lord, in whatsoever caption, my lord, they have asking for vacating of the initial order of injunction that has been passed by exercising of the power under Order 39, Rule 1 and 2. Now, while my lord exercising my lord's previous round of litigation under Article 227, the matter has not yet been adjudicated then by the trial court. So, my lord, that's why, my lord, today I can ventilate, my lord, because that's the point where, my lord, the court has not exercised the power by, my lord, taking up their application for vacating on merits. But today, not only that has been done, an order on merits regarding their vacating application has been passed, coupled with the court has applied his mind and now a fresh.
Why is the court not finishing the application under Order 39 Rule 1 and 2 completely? What is the problem? Why is it being adjourned?
That's because they want their vacating to be.
Are there in this? Service on all of them is complete.
1 to 4.
Service on all is not complete as yet.
No, this is the matter.
Service on all of them is not complete.
That's my lord, I have to take instruction. Readily, my lord,
no.
That's my lord, I have to take instruction because this application is being preferred by my lord, the petitioner hearing. Now, my lord, where I was, that here simultaneously both these two power is being exercised because your lordship's order is that prior to extension you have to decide it on merits. So today 39(4) application has been decided on merit coupled with the power of extension. It's a fresh extension because the court has applied its mind on a fresh way and thereafter not only rejected their application for vacating but also extended the interim order. So, my lord, in my respectful submission, this, my lord, particular, my lord, combined order comes under the purview, because, my lord, today, whatever the case is, if today, my lord, even, my lord, I shall show before your lordship one of the division bench judgment wherein this similar, my lord, case arises. There was a caveat lodged. There was an allegation with regard to the defect of caveat. That's the city court matter, my lord. The caveat noting was there, but in spite of that, the interim order has been obtained. Now, it came up in first miscellaneous appeal before this honorable court, and this division bench of this honorable court ultimately directed the matter to be heard afresh. So, my lord, I can take aid of a similar situation, because, my lord, there are thousands of cases, my lord, we all know that where there isn't a power exercise under Order 39 Rule 4, it comes squarely under Order 43 Rule 1R. So there is no quarrel on that. Or regarding Order 39 Rule 1 and 2, my lord, there is also no quarrel. Yes, my lord, it's appealable. But the case in hand is that which your lordship wants to distinguish rather from Order 39 Rule 4 window, that if it's really a case of non-service of summons, in spite of a lodging of caveat. But may I just cite that judgment first, since, my lord, it's disturbing your lordship mind. Division bench. FMA 7, well, it's reported subsequently. Yesterday, my in other side. Double print. If your lordship takes up. Well, it's a case in hand, below your lordship kindly takes up the facts. Initial few paragraphs will suffice. I just wanted to demonstrate before your lordship, even in this kind of cases, the appellate remedy, because, beloved, under Article 227, I'm not troubling your lordship regarding the other facts of the matter. Lord, I had an opportunity, Lord, to appear. Yes. Now, my lord, if your lordship takes up the first volume, my lord, page 94, what is the application about? Lord, I have shown before your lordship this judgment only for the purpose that to assist your lordship, because this is something, my lord, I have also not gone into, because Order 39 Rule 4 in whatsoever ground, it's applicable, my lord, the other grounds as enumerated under Order 39 Rule 4, we find, my lord, many times. But in case of a non-service of summons, it's something, my lord, which we also, my lord, very few, my lord, we came across on this. But I had an opportunity in this kind of matter, my lord, to appear, my lord, where, my lord, the exact, my lord, same thing happened.
Yes,
And
but it was not held there that it is not revisable. This is not a case. This is not a case in support of the proposition that such an order is not revisable, or that
if
because here there was no case of a recalling application being filed. In this case, there was no application for recall.
More so, my lord, that's why I comes More so, once the recalling, that's why I inviting your lordship.
The only problem there, Mr. Mukherjee, is that if an application is one for recall, which does not form any of the grounds which could have fallen within the scope of Order 39 Rule 4, then in that case, it will not by dint of Order 39 Rule 4 provisions become appealable under Order 43 Rule 1R. You have to show that the grounds which have been taken in the recalling application are grounds which were available.
But that's why,
that is what the idea is. 151 injunction can be granted only if such injunction could not have been granted in Order 39 Rule 1 and 2 or Section 92(6) or whatever.
Yes. 94C.
94(6). If the injunction is within the periphery of 94C or Order 39 Rule 1 and 2, 151 is ruled out.
Ruled out.
No matter how you caption it.
Yes.
But if it is beyond the scope of these two provisions, then
like Section 8 Land Reforms Act once filed the injunction application. It has to be under 151 because it cannot come under Order 39 Rule 1.
It will not be an appealable order. Here also similarly, if you import the same logic, then in that case, if it is not strictly a case under Order 39 Rule 4, then it would not be appealable under Order 43 Rule 1R. If it is not under Order 39 Rule 4, then it has to be one under 151. If it is 151, provision not exercisable, power not exercisable under Order 39 Rule 4 has to be revisable. Otherwise, he'll be remedialess because appeal doesn't lie.
Lord, I am coming, Lord. Yes, Lord, I understood, Lord, what is troubling your Lord. Lord, kindly takes up now page 94, first volume, their application for modification. Lord, your Lordship knows, Lord, under Order 39 Rule 4, the prejudice.
Modification is not
Rather vacating application. May I, Mr. Roy is annoyed with me, Lord. Why, Lord, I said to Lordship, it's modification. Lord, it's not only, Lord, recalling, it's vacating also. But Lord, I will not, Lord, trouble your Lordship regarding the, Lord, caption, because caption is immaterial. If ultimately today your Lordship is of the opinion that I cannot come under the window of whatever, Lord, the grounds available, Lord, your Lordship knows, Lord, 39 Rule 4, the prejudice factor is also there. Hardship. If someone is under hardship, and today your Lordship's view is that if 148 capital A is only the ground of recalling, then my learned friend cannot come or cannot qualify that he has filed an application, maybe with a wrong caption, but it comes under 151 or under 39(4). So we have to, Lord, narrate what is their application about.
Again, Mr. Mukherjee, Order 39 Rule 4 also is broad enough.
Broad enough.
Because it says
I shall place that also.
Any order may be discharged, varied, or set aside. Now, when you seek recall, in a sense, you are seeking setting aside. Now,
not only they have vacating also.
The proviso to the main section is an exception. Fraud is not supposed to be the always the ground
of non-service. Yes, Lord, absolutely.
It can be anything else.
Absolutely.
Now, if it is anything else, then you have a point saying that yes, it becomes an appealable order.
More so, my Lord. More so. What is troubling your Lordship? Just a point. What is troubling of your Lordship? That they are only aggrieved with regard to non-service. And if Mr. Mukherjee, their application is restricted to the part of non-service, then why they could not come under 151? Why these regards of 39(4)? Kindly now takes up their application. Apart from looking at the caption, I shall place two paragraphs and the prayer also. Kindly takes up page 94. What is caption? I again remind your Lordship, I am not pressing with regard to whatever caption they have used, but they have used the caption that application for recall and vacation of the ad interim order. Now, takes up their first initial paragraph up to paragraph 7 is with regard to the filing of caveat and all procedural. Kindly may I allow to place paragraph 8, 9. and 11. That the petitioner first came to learn the impugned ad interim order of injunction only on such and such when the main and agent of the plaintiffs came to the suit property and supplied a copy of the information slip from which the petitioner gathered knowledge of the said order. The petitioner had not received any prior notice, summons, or intimation of this nature whatsoever from the either of the plaintiff of the learned court. A copy of information slip is being annexed. 9. In fact, it is stated further that the suit dug along with the other contiguous dug housing project, namely such and such, and on 26th of February 2026 itself, and the main and agent of the plaintiffs came to the suit plot and pasted the notice at the entrance of the project. A purported notice of injunction is a bid of to blackmail the intending purchaser of the project. Comes to paragraph 11, Milord. The petitioner is a company engaged, has your lordship got it, Milord? Engaged in lawful business relating to the suit property and has substantial right, interest, and investment. Milord, I am pressing this, keeping on mind of 2008-11. Prejudice, investment, substantial construction. Therein, the continuance of the impugned ad interim order is causing and
811-1.
Page 1. And will continue to cause irreparable loss, injury, and prejudice to the petitioner, adversely affecting its lawful commercial activities.
Have come up. That was the line. Justice
Yes. So, Milord, they have not, this paragraph, Milord, itself, broader their, Milord, the aspect of their, Milord, petition. They could have restricted it, but they have used one of the vital limb of Order 39 Rule 4. And what they have prayed, Milord, they have prayed recalling of this order and vacate and also for stay. Prayer B. Recall or vacate. And Milord, Mr. Let me, Mr.
Only one thing. Lord, what is the ultimate relief that they could have got in this application? Either the injunction could have been vacated, the injunction has been kept now, and extended by the impugned order. So, Lord, this order has to be assailed in appeal only because it comes within 39(4). Because Mr. Mukherjee has shown your lordship paragraph 11. But kindly have a look at Lord one judgment of your lordship's coordinate bench. The judgment of the same issues, Lord, identical issues, whether 151 or appeal was Lord taken out by argued in detail. Kindly have a look at that, Lord. At a copy to the other. Kindly have a look at this, Lord. First, my Lord takes paragraph 2. The order impugned herein is an ad interim order of injunction passed in terms of prior of the petition so and so. At the ad interim injunction was extended from time to time, and the extension orders have been challenged in the civil divisional application. Therefore, all the civil divisional applications are heard analogously and being decided by the common judgment. 10 minutes kindly comes to para 5. Mr. Mitral, our senior counsel representing the opposite party number 2, also raises an objection as to the maintainability of the appeal, as according to him, the nature of the release paid for and granted by the learned trial court falls within the scope of Order 39 Rule 1 and 2 of the Code of Civil Procedure. He placed reliance upon the decision of the Honorable Division Bench in the case of Sukhendu Maiti and so in support of his contention that an appeal lies against the impugned order and therefore the civil division application is not maintainable. Then my Lord kindly takes note, paragraph 12. The impugned order was passed on an application captioned as 1 under 151 Civil Procedure Code. Question that falls for consideration in this revisional application is whether this application is maintainable or not. Then, para 14, Mr. Banerjee would contend that the order of injunction passed by the learned judge was under 151 as the relief sought for by the opposite party are not covered under 39(1) and 2. On the other hand, Mr. Mukherjee contended that the reliefs sought to be squarely covered under 39(1) and 2. Then, Milord, kindly take paragraph 16, the second sentence. Therefore, if the nature of the order is one which is passed under 39(1) and Rule 1 and 2 of 39, an appeal shall lie from Order 43 Rule 1R of the Code of Civil Procedure. Whether an order is appealable or not is not dependent on the caption of the application. It is only the nature of the order which is relevant for deciding as to whether the same is appealable order under 43(1), the last sentence calculated, therefore, an order under Rule 1 and 239, which is applicable under 43(1)(r), has to be challenged. So that was the submission. Then para 17. Now the question arises whether an order of injunction passed on an application filed under 151 of the code is an applicable one. The said issue is no longer resenting. The Honorable Division Bench in the case of Sukhendu Maiti Supra reiterated the well-settled proposition of law that in the deciding the question whether a particular order is applicable or not, the court should not guided by the wrong quotation of the provision of a statute by the court in the order impugned or by such wrong description given by the parties in an application upon which the order was passed, but should find out the exact provision of the statute which authorized the court to pass such order. In Banwarilal Jalan, it was held that if the court really passes an order of injunction within the meaning of 39(1) and 2, but the application on which such order is passed is erroneously described as one under 151, for the reasons one cannot lawfully contend that the order does not come within the purview of 43(1)(r) of the code and should be revisable one. It was further held that the authority to pass an order does not depend upon the wrong quotation of the section 20. In the light of the proposition of law laid down in the said report, this court holds that for deciding as to whether the order impugned is an applicable one, the court should look into the nature of the relief sought for and the order passed thereon rather than form the application. This court has already observed the relief's claim falls within the scope of 39(1) and 2. The authority of the court to pass orders which are impugned herein flows from 39(1) and 2. This court therefore holds that the order impugned was passed in excess of the powers conferred under 39(1) and 2. This court further holds that the impugned order is applicable. Then Mr. Banerjee would contend that the application under 151 ought to have been rejected in case the relief sought for, in the opinion of the court, falls within 39(1) and 2. This court is not inclined to accept such contention of Mr. Banerjee in view of the decision of Sulekha Works, wherein it has been held that the litigant should not be deprived of the remedies merely because of a particular section. That's a nomenclature. Then kindly take para 23. Now the question arises, availability of remedy by an appeal bars the exercise of supervisory jurisdiction of High Court. Para 24, the Honorable Supreme Court.
Virudnagar.
So, Lord, kindly have a look at now 39(4) first proviso once. Kindly have a look at that. Absolutely. Lord, there are three components: order passed without giving notice, material suppression or misrepresentation, and prejudice, and there is a change of circumstances. On this foreground, kindly have a look at that. Provided that if an application, first proviso for temporary injunction, or an affidavit supporting such application, a party has knowingly made a false or misleading statement in relation to or material particulars, and the injunction was granted without giving notice to the opposite party, the court shall vacate the injunction unless the reasons to be recorded it considers that it is not necessary so to do in the interest of justice. Order was passed without giving notice to them. So first proviso, then kindly take the second proviso. Provided further that where an order of injunction has been passed, after giving a party opportunity of being heard, the order shall not be discharged, varied, or set aside on an application of that party, except where such discharge, variation, or setting aside has been necessitated by change of circumstance, or unless the court satisfied the order caused undue hardship. Para 11.
This doesn't apply because they were
So
not
first
heard.
proviso is on without notice. So even it is without notice, but kindly appreciates one thing: if the application would have been allowed, injunction would have been vacated. Today, what the learned judge has done, he has kept the injunction and extended. So it's a single order having two components. It has to be challenged in appeal. The application may have been couched as an application under 151. The prayers, the pleadings, all indicate towards a relief of vacating the interim order. Lord, they should approach the jurisdictional appellate court. And if I have no case, I will have to fight it out there.
Yes. Why don't you?
That is right. Absolutely.
Mr. Chaudhary.
Lord, please see the application.
Yes.
Maintainability.
Yes. On the maintainability, these are our submissions. On the
You finish.
No,
We don't
you
want to
answered
serve
that.
it.
Lord,
It is
just,
not maintainable.
I get
Yes.
the point of maintainability.
If it is
Lord,
not
I'll just take 2 minutes, Lord. Page 94 is my application. It is one under section 90. Lord, please see what it's under. Application for recall, vacation, etc. And please see the prayer now. Recall and or vacate the ad interim order of injunction dated such and such against defendant on the ground same has been passed in flagrant violation of statutory mandate under section 148A of CPC and without notice to the party despite registered caveat. Lord, it's really, and now, Lord, please read it with paragraph 4. Upon inquiry and verification, petitioner has come to understand that at the date of hearing of the injunction application, learned Chiristedar of this honorable court did note a caveat. However, by mistake or oversight, caveat noted was caveat number such and such, filed by Avenue Properties against the plaintiff in such and such with a different property, different caveat altogether, having no nexus whatsoever with the suit property of the petitioner. Petitioner's duly registered caveat number pertaining to such and such was neither noted nor brought to the attention of the learned court, as a result whereof name of petitioner was missing from the caveat note and petitioner was deprived of a statutory right of hearing. And this is the sole ground. I go to court and I say very next paragraph, Sherestadar's mistake, act of court cannot, my lord, prejudice anybody. Please recall the order. This is not, my lord, 140. This is not under Order 39 Rule 4. Kindly see, my lord, Order 39 Rule 4 proviso has two, my lord, conditions.
Proviso, Mr. Chaudhary, is the exception to the main provision.
Yes.
The main provision is that you can seek varying vacation setting aside.
Yes.
Now, but will this recall then not amount to setting aside the order?
I'm really asking for recall or set aside. But on what ground? Ground of
Mr. Chaudhary, what are we concerned with? The result or the ground? Because what is being challenged ultimately?
substance. Your lordships have held, my lord. Substance of, my lord, the matter is what matters.
The remedy will be decided on the basis of the relief. Injunction granted or not granted, on whatever grounds, will be an appealable order. Injunction vacated or not vacated, on whatever grounds, should be an appealable order.
For example, my lord, this would be within the realm of a procedural review. For example, tribunals which do not have power of review, in such a case, you can file an application for recall, and this will be considered to be a procedural review under inherent powers. Tribunal regulate.
The only difference is till such time that there is no provision in the code, you can bring it within the realm of 151. But the moment the remedy that you seek fits into any of the pigeonholes of the code, you have to approach the appropriate hierarchy, superior hierarchy for getting redress of whatever grievance you have before the.
I'll have to meet, my lord, scope of Order 39 Rule 4. If it's beyond scope, I go home.
Yes.
If it's within scope, then, my lord, I carry the certified copy and go back to Baraipur court. May I just come back tomorrow, my lord?
Tomorrow he said he has some difficulty.
তুমি থাকছো না? Tuesday, my lord?
কেন no tomorrow থাক না না আমি থাকছি না
আরে
ঠিক আছে
no
না ঠিক আছে
না
I will complete. No
going on a holiday
then I am
why should we
completing.
suffer
I am taking
why should we suffer Mr. Rai and Mr. Mukherjee going on
God
a holiday?
practice by the court or upon the court.
Why
It
should
will
we
be
decided by this court. Whether 227 power is denuded.
Mr. Roy
Decide the same.
Roy will also address.
goes on a holiday মানে বেড়াতে যাচ্ছে কালকে কোথায় কাবিনি সেই জন্য বলছে থাকবো না কিপসিরাম না any day as per law
very required.
বেড়াতে যাচ্ছে কোর্ট ছেড়ে বেড়াতে
This revisional application is directed against an order dated, and on when is the injunction? Since you started first,
Mr.
Chakravarti appears for the opposite.
Here to
Petitioner preliminary point to নিজের application.
5 दिन দিছি আমি নিয়ে গেছি
Opposite part. Agreed to a date.
Agreed to a date, Wednesday.
I have instructed to keep the matter on 29th, next Wednesday.
Wednesday?
Oh, you are there. 29.
29th.
29th, if it is your lordship's pleasure to keep the matter at 2 o'clock.
29th কিছু time frame আছে নাকি?
2 o'clock, it's only if the petitioner is agreeable, then
2 o'clock we'll have original side.
or any other time in the 12:45, 12:30, or 1 o'clock.
Anytime before recess.
No, but if the petitioner is not agreeable, then we'll have to argue on merits.
Yes.
If the petitioner is agreeable, then the matter can be disposed of.
Lordship, my instruction is we have already concluded our argument and let them first.
You will not be able to, you will not be required to reply to his arguments.
Yes, Lordship.
Make submissions which make sense.
At 12:30, will it be a lordship's pleasure to keep it? 12:30? Grateful.
12:45 30টা অনেক ইয়ে হয়ে যাবে। লিখে নিন, অর্ডার লিখে নিন।
12:30. 12:30.
12:45.
Much obliged.
As suggested by the
if your lordship wants, I have documentary evidence to prove my urgency. I can even show that court. I mean, I am in extreme financial distress. Kindly consider this, my lord. I have having documentary evidence.
No, this is
medical
a hearing matter. I only have urgent matters determination. Hearing matters are not considered that urgent.
Your lordship, I am facing severe financial distress. I am having.
Try to understand. I am not having the regular determination. And in any case, your suit is there. Your prima facie, we had opined that your revision is not maintainable.
No, your lordship, I think you have forgot your lordship. Last day's order, your lordship has written in order that for further consideration and judgments what I have produced. If your lordship feels that by no, I'm saying, sir.
Yes, but I don't have that determination anymore.
Charge with your lordship kindly consider
Only
my
for
urgent-
urgent, only for extremely urgent matters. I cannot take
Extremely
take
urgent
up
for
hearing
my-
matters.
Extremely urgent. I
That
can
is there
produce
for
the
every
documentary-
litigant.
I can produce the documentary evidence.
Let us see.
If your lordship